My lord, my lord, maybe.
Lordship, may I permitted to mention? Your Lordship, I have mentioned it on Friday, Your Lordship. Your Lordship ordered me to come today, Your Lordship. Lordship, I have sub all the other sites. They're all
What
are
is the
here.
matter?
The matter is led to 7 SLST. It's a part-heart matter. I have mentioned it on Friday, and Your Lordship ordered that come to today because it was appearing in today's list. But unfortunately, it is not appearing, Your Lordship. It's a part-heart matter.
Wait.
Kind Lordship, give a
Which
date.
date,
Kind of, all the other sites are here, Your Lordship.
Which matter? Along with which matter this will appear?
There are 4 matters mainly. Apart from the
Which
7
are the matters along with this matter will appear? Which matter?
The ABM Abdullah and Masood Billah.
The matter
Listed
relating to
today.
the 7
Seven
SLST upper primary applicant.
It is listed today.
recruitment.
It was supposed to be listed today since
Oh.
it was appearing in Wednesday list, but it's not listed.
Okay. ঠিক আছে।
Kindly fix the date and time, Your Lordship.
Come on Friday.
My lord, may I be permitted to mention one matter, my lord, for restoration. My lord, it was dismissed on 25/8/2020.
Matter is appearing under the heading or orders. By the present writ petition, the petitioner seeks for direction upon the respondent authorities for appointing the petitioner to the post of assistant teachers in terms of notification dated 28 November 2022 by recasting plus modifying the recommendation list. The petitioner contains a C. Participated in Teachers Eligibility Test State 2014. However, she was she was unsuccessful. By the order of this court, 6 marks were awarded for wrong answers. By dint of which the petitioner was declared qualified in TET 2014. This awarding of marks was given on which date? 22.
22.
In the year 2022.
21. Awarding of marks.
That's 2021.
2021.
I'm sorry, 2021.
Since the petitioner was not declared qualified in the year 2016, he could not participate in the recruitment process initiated in the year 2016. With the qualification of TET 2014, the petitioner should be allowed to the candidature of the petitioner should be considered for a recruitment process of 2016. Hence this writ petition. Mr. Vishwarup Bhattacharya, learned advocate for the petitioner, submitted that the order is that awarding that there was gross irregularity in the recruitment process of 2016. Top untrained candidates were given appointments in 2016 recruitment process on the ground that there were no trained candidates. The right of the petitioner to have his candidature considered in the recruitment process of 2016 is based on the order of this court passed on 5th September 2022, passed in WPA 5505 of 2022. Soham Roy Chaudhary and others versus State of West Bengal and others. He seeks for appropriate orders for issuance of appointment letter in favor of the petitioner in pertaining to recruitment process of 2016. On the contrary, Mr. Subir Channa, learned senior advocate, appearing for the board, submits that in the year 2016, the minimum qualification in CT August 2010, which minimum qualification, Mr. Biswas, in CT notification 23rd August 2010.
My lord, your lordship will find in the spiral. The
Yes.
lordship will not hear it. My lord, I am just handing over.
Page number. Spiral binding I have taken.
Yes, my lord, 53.
50. Minimum qualification for classes 1 to 5 was senior secondary with at least 50% marks and 2-year diploma in elementary education. The petitioner is not a trained candidate. Therefore, in the year 2016, she was not a qualified trained candidate to participate in the recruitment process of the said year. He further submits that the petitioner has subsequently participated in the recruitment process initiated in the year 2020, but could not qualify since she was not having 50% marks in graduation as required in the notification of the NCTE.
Page, my lord.
That includes the B.Ed.
Annexed in the supplementary affidavit, your lordship. Page 7.
And B.Ed. Dated 28th June 2018. Full stop. फिर sentence पे बोलूं तो 18. relying on the decision of Honorable Supreme Court passed in Loka Nadham versus Chairman Telecom Commission and others, reported in 2008, Volume 5, SCC 155, he submits that the petitioner participated in the subsequent recruitment process without any demur. The principle of estoppel, therefore, would apply in the case of the petitioner. Furthermore, Judge 2019, status. Furthermore, the panel has already expired upon lapse of 1 year from the date of publication. Therefore, the petitioner cannot claim for allowing her candidature in respect of a panel which has already expired. For a bracket A, Rule 12 of 2016 recruitment rules, page number
My lord. 115, my lord.
150.
115.
Rule 12 of rules of 2016. পুরো নামটা দেবেন ওয়েস্ট বেঙ্গল প্রাইমারি স্কুল টিচার্স রিক্রুটমেন্ট রুলস 2016 হিয়ারিন আফটার রেফার টু অ্যাস, এটা ব্র্যাকেটে দেবেন না। Reliance is also placed on the decision of Honorable Supreme Court passed in Ali Hossain Mondol and others versus West Bengal Board of Primary Education and others, reported in 2024 SCC Online SC 1189. He seeks for dismissal of the writ petition. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the petitioner in the facts and circumstances of the present case is entitled to appointment in recruitment process initiated in the year 2016. Indisputably, the petitioner did not have the qualification of diploma in elementary education in the year 2016. The NCTE notification dated 23rd August 2010 provides for following minimum qualification. This was 1 to 5. Classes 1 to 5. Eta porben. Ei je minimum qualification, page 53. নিয়ে নেবেন page 53 লিখে রাখুন, page 53 of spiral binding.
53 and my lord, which was amended in 55, page 55. The same, my lord.
55, which one? 5.
55. I'm sorry, my lord, 56. I'm sorry, 56.
এটা amended on 29 July 2011. এই ঠিক আছে, শুধু 1 to 4, 1 to 5 ওখানে যেটা আছে অ্যামেন্ডমেন্টটা পরে 1 to 5 ক্লাসেস 1 to 5 আর কি। 53 and 56.
আজকে ডাক তো কোথায় গেছে?
Upon going through the aforesaid notifications, there cannot be any manner of doubt that 2-year diploma in elementary education was a requirement as per the aforesaid notification, which the petitioner did not have. Moreover, the petitioner participated in the subsequent recruitment process initiated in the year 2020. In which paragraph he has stated that he has participated in that?
2020, my lord, I'm just.
তুলে গেল না
2020.
My lord, paragraph 8.
Paragraph 8.
My lord, paragraph not 8. My lord, paragraph 7.
কি
ওই বিদ্যালয়ে পার্টিসিপেট করেছিল। এবারে পাঁচটি করেছিল।
But paragraph 7. 7, Malad, it has to be called out from 2-3 paragraphs. And we have stated in our affidavit, paragraph 7, 738, your losses will find qualified. That's as per the order of the Honorable Court. And then paragraph 9.
In your supplementary affidavit, you have stated
Yes, yes.
the
6C.
board in its supplementary affidavit have stated that the petitioner participated in the subsequent recruitment process of 2010, which has
2020.
2020, which has not been disputed by the petitioner.
Paragraph 4.
In Lokadham Supra, the Honorable Supreme Court observed as follows: 1718. 18. Bearing in mind the aforesaid proposition, the petitioner is stopped from raising or claiming her right in respect of the recruitment process of 2016. Undeniably, the panel of recruitment process of 2016 has expired. 19 in Harish Chandra, Supra, the Honorable Supreme Court, is paragraph number 9. 9 ta quote, 9. In Ali Hussain Mondol Supra, para 29, set out. 29. Keeping in mind the aforesaid proposition of law as laid down by the Honorable Supreme Court, the petitioner cannot claim his rights after the expiry of the panel as per Rule 12 of the Rules of 2016. In light of the aforesaid discussion, the writ petition falls short of merit, accordingly dismissed. Dismissed.
Great.
Much.
2016.
হ্যাঁ হ্যাঁ যে কোনো দিন
Item 2, I am for the petition.
My lord, item 2, my lord, I'm led by Mr. Sandal, my lord. Yesterday, my lord, at 5:30, my learned friend has, my lord, subbed the notice, my lord. I could not, my lord, find out the brief. My lord, your lordship, take it up any other day, my lord. Even I, my lord,
কেন to be mentioned কেন?
Well, at the time of mentioning, we have served. Again, my lord, yesterday.
mentioning it was not subbed upon us. Directly,
No,
my
no,
lord, it is emailed to the, my lord, board.
Absolutely.
Anyway, why this has been listed under to be mentioned?
I mentioned the matter because, my lord, the recruitment process initiated by the West Bengal Board of Primary Education. Now, petitioner came to know that after publication of the list in 2023, the list of successful candidate as well as the cutoff last marks of the marks of the empanel candidate in each and every category in respect of the district. Petitioner came to know that their marks is higher than the marks of the appointed candidate, even without adding the marks of the interview and aptitude test.
Is more.
Yes, kindly see page 53 once.
2016 recruitment
No, no,
process.
no,
The
just-
issue has
just-
been, my lord, decided by the division bench.
No.
50, kindly come to 53, page 53. (53) of the writ petition, that is annexure P4. Kindly serial last Rakhi Dattho. Kindly the serial number 1, 2, 3, 4, 5. Fifth person. Rakhi Dattho is the petitioner number 1 before your lordships. She secured 11.822 marks in the recruitment without adding Viva and aptitude test, because, my lord, the primary board did not disclose the marks of the Viva and aptitude test in the recruitment process. Now kindly come to the next page.
No, this document has been obtained from which authority then?
Primary board
When did they disclose?
disclosed in the year 2023. And kindly see page 54 once.
Who are the candidates who have been given appointment? Who are having the lesser marks than the
Page
petitioner?
54, the candidate marks is there. Their marks is 12.906. Serial 429. P. Hori Prasad. If I see general category candidate 12.905, if the interview marks and Viva marks is allotted to the petitioner, then she will get chance.
Okay. You have filed your opposition, or you will be filing in the
Can you take it up, my lord, in the same heading, my lord, any day, my lord, let me, my lord, find out the brief, your lordship, my lord.
This matter
Yes,
is
yes,
appearing
any
under
day,
the
any
heading to be mentioned. Mr. Ratul Visas, learned advocate for the board, seeks accommodation. Right. কবে আসবে তাহলে? নেক্সট উইকটা বাদ দিয়ে পরের উইকে দিয়ে দিই। নেক্সট উইকটা বাদ দিয়ে পরের উইকে দিয়ে দিই। 29 to be mentioned এ রাখি। এটা তো আমরা
brief না পেলে
মানডেতে রাখতে পারি।
আমার কাছে
মেসেঞ্জার এসছে। মানডেতে রাখো 27। It will appear under to be mentioned on 27th.
Yes, yes.
And my lord, the one of the another predicament is this matter was, my lord, initially tagged on their pair, my lord, with the Shantanu sheet. My lord, I've checked up, my lord, since I didn't get the brief, my lord, in the website, my lord, I've
On
checked
the
up
last occasion, it
was
was tagged with the
Shantanu sheet by the order.
I mentioned and segregate the matter.
Next.
Grateful, my lord.
3, I am for the
And
petition.
there is one CAN application filed. What is this? 1 of 2025.
Can application for addition of party. Some similarly situated candidate file the
A
application.
copy has been given.
Yes, yes.
Find
yes.
out and if
Yes,
not,
yes.
give a copy.
On 27th, I
Get 29th, rather.
27th, on miscellaneous.
item number 3, I am for the petitioner. It in the matter for filing the report, direction was given on 2nd February 2025. 2nd February 2020 till date, no report has come from the DPSC.
This is DPSC North 24 Parganas.
Yes. there are vacancy, and our case is that previous same to as previous case, that my marks is higher than the appointed candidate. And what has happened in the recruitment process, OBC, in respect of OBC candidate, the DPSC declared that the last impaneled candidate marks is 41.08. Now, after getting our marks through RTI, we came to know that our marks is lower, admittedly lower. Subsequently, they lowering down the cutoff, the DPSC lowering down the cutoff, appointed 6 candidates in terms of the order of the Honorable High Court in another writ petition. And those candidate marks is lesser than the marks of the petitioner. Peculiar fact. If the DPSC lowered down the marks in respect, cutoff marks in respect of OBC category, then benefit should go to all candidates.
Yes.
And on the last occasion also, your Lordship was pleased to give direction, extend the time of affidavit in operation till that.
So they are not appearing for DPSC now. Mr. Boisho
Mr.
and
Boisho and today they will not appear. Yesterday I had a telephonic discussion, they will not appear. They have the instruction not to appear.
then the state will appear, because in other district,
Yes,
the district
yes.
inspector
The
of schools have
DI is the authority now.
We have to take instruction.
you will appear. Yes, sir.
রাখো, কিছু করতে হবে।
After the change of panel of the state advocates, you have served copy.
Yes. করেছি
Copy of it.
আমি দিয়ে দিচ্ছি তাহলে কপি নাও।
This
I can
matter is
give the copy again.
this matter is appearing under the heading to be mentioned. None appears on behalf of DPSC North 24 Parganas. It is informed by the learned advocates that presently the district inspector of schools of the concerned district is discharging the functions of chairman of DPSC North 24 Parganas. Accordingly, learned advocate for the petition is directed to serve a copy of the writ petition and its annexes upon learned advocate for the state. Give a copy.
Yes.
Please, this matter. Find out this is pending since long, 2023. There was a direction to file affidavit in opposition that has not been filed. If you intend to put in your affidavit in opposition, do it within a period of 2 weeks, up 1 week to file reply. And after 3 weeks, this will be listed. Or if you say that you will not be filing, then it's all right. We can proceed with the hearing.
Yes.
3 weeks for a disclosure. After direction the other, they let such affidavit in opposition be filed within a period of 2 weeks, 1 week to file the reply. This matter after 3 weeks. It to be mentioned in IR.
Time may be given by nothing.
Otherwise,
Otherwise,
hearing a list din. Please, bolun. 6/8. 6th August.
Yes. Obliged.
Item 4.
4 is similar recruitment, similar situation, similar order. First.
It is also not 24 Parganas.
Yes, similar recruitment.
ঠিক আছে।
Copy গুলো দিয়ে দেবেন।
হ্যাঁ, দিয়ে দেবো, আজকের মধ্যেই দিয়েছে।
Same order করে দিন। 3 weeks পরে
Line দিয়ে দেবেন। Obliged, get through.
Item 5.
For the
5.
petitioner,
What is the correction? This matter is appearing under the heading to be mentioned.
last order dated, my lord, para number 7, only year, my lord, wrongly recorded, your lordship, 2025, your lordship.
Inadvertent typographical error has crept into order dated 21st May 2026, mentioning the 2026 in paragraph number 7 in second page. 1, 2, 3. What will be?
Fifth line, my lord, 2025, but wrongly
The
recorded.
words 2, 3
Fifth.
in the 4th/5th line. 4th December 2025 instead of 4th December 2020, sorry, 4th December 2015 instead of 4th December 2025. Let the words in paragraph number 7 at page 2 in line 4th/5th be read as 4th December 2025 instead of 4th December 2015. The other portions of the order shall remain unaltered.
Item 6. May I please, Lordship, I am for the petitioner. This is my affidavit of service. Last occasion, I only served to the learned government leader. That's why your Lordship directed me to serve copy of the restoration application to all the respondent. I have done it. They have received it. My lord, the matter was dismissed for default on 12th June 2023, and the application is filed within the time. My lord, it is with regard to the 5 marks. My lord, 5 wrong question has been indicated in the 2014 state examination. That point has been settled by the Honorable Supreme Court. The state government has directed to give 5 marks to all the candidates, and after giving the marks, who will come under the purview of zone of consideration, they should be issued the my lord, the certificate of state. And my lord, now the Dildoria government, state government has also extended the age of the participants. So I am coming with the zone of consideration. Well, kindly distort it and fix a matter for any date so that matter can be disposed of.
Board you have served?
Yes, I have served board. Malad, second affidavit of service I have filed it.
Affidavit of service filed on behalf of the petition is taken on record. This is an application seeking for restoration of the writ petition upon recalling order of dismissal dated 12 June 2023. Mr. Swenso, learned advocate for the petition
Grounds, my lord, paragraph number 3 onwards. It has been assigned, my lord, the learned advocate who is appearing on behalf of the petitioner. He was not come on the day of hearing of the matter.
Submits that applicant
Paragraph 4 is the relevant.
submits that due to illness, the learned advocate could not appear on the date the matter was taken up for hearing, resulting in dismissal of the writ petition. He seeks for restoration of the writ petition upon recalling order of dismissal.
Item delivered. It shows item delivered.
Despite service, none appears on behalf of the board. State is represented. State is represented. Ms. Sudeepa Banerjee, learned advocate for the state respondents, leaves the matter to the discretion of the court. Upon going through the contention of the application, it is found that the cause shown is sufficient to restore the writ petition upon recalling the order of dismissal. Next, accordingly, the order of dismissal dated 12 June 2023 is recalled. The writ petition being WPA 23187 of 2022 is restored to its original file and number. Can 1 of 2023 stands disposed of. Was there any direction to file any affidavit?
No, this is the on motion stage it has been done. My lord, kindly fix any date. My lord, that's because the already the point has been settled and directed.
Place the matter on after 2 weeks.
My lord, can
Learned advocate for the yes.
I shall communicate this order to the board as because they are main answering respondent and they have not appeared today. My lord, can it be fixed on my lord in priority basis in offer so that that matter can be disposed of.
3rd August. Thursday কততে থাকবে এটা?
হ্যাঁ,
Okay. Learned advocate for the petition is directed to intimate the next date of hearing.
I think that 3rd August is the monthly list will be published.
3rd August is the monthly list. তাহলে পরের উইকে দিয়ে দিন 7th.
Deep, much grateful. Much.
Much obliged.
Item 7.
I am both the petitioner. One of the petitioner.
This is Secretary of
Yes,
Secretary of
the whole my lord.
Managing Committee.
The Baragachia
Secretary of the Managing Committee.
Correct.
And Director of Madrasa Education.
Yes, I am sir.
Sir.
First letter. Can you see first letter?
Director of Madrasa Education. Madrasa Education. Okay. State is there. District Inspector of Schools. State. Teacher in charge, sir.
Sir.
Oh. Yes.
Now the petitioner, my lawson did not open the paper. Kindly hear me to understand. The petitioners having the honors degree in history was recommended by the School Service Commission for appointment of an assistant teacher in history in respect of the present madrasa. Now thereafter, my lord, he has been teaching the subject in history, and subsequently he made an application for higher qualification, that is master degree in history. Managing committee has recommended and has given the permission that you go to take the higher qualification. Simultaneously, he made an application, managing committee made an application before the DI for seeking permission so that the petitioner can take the higher qualification. This letter, which was forwarded by the managing committee to the DI, this letter, prior coming to the School Service West Bengal Control Expenditure Act 2005. DI did not take any action, nothing of this sort. Now, immediately thereafter, he admitted under the Netaji Open University to distance course. So the teaching cannot be hampered. He subsequently he appeared in the examination, and all these examinations were holding in Sunday. Therefore, there is no question to take leave. Now, after that, in 2009, he obtained the master degree. Master degree, after obtaining, he made an application for higher scale of pay. On a higher scale of pay, the managing committee also forwarded all these documents to the DI of school. DI did not take any action. DI issued a letter to the Madrasa board. What can be done? You kindly give the instruction. Madrasa board also issued a letter to the DI. There is a correspondence. Subsequently, my lord, the prior permission, post facto prior permission was given. After post facto permission was given, now I am entitled to get the higher scale of pay because the prior permission, when it has been given, now there is no question of any prior permission. I have not possessed any power for nothing of this sort. Now, immediately after giving the prior permission, I made an application there. You kindly grant the higher scale of pay because I am entitled to get the higher scale of pay. Now, the letter was issued by the DI relying upon a circular that is 27 November 2011, 2007. The circular provides that prior permission is required. I will show all this required. That letter is challenged before a lawsuit. Now, I have got 3 judgments, including the special bench judgment and the division bench judgment. First of all, 27 November 2007 circular is not applicable to me because the circular clearly provides that prior permission is required in case of obtaining the higher qualification. When prospective permission has been given to me, 2007 circular is not required, is not applicable in case of myself. Now the division bench judgment has also, I will produce the division bench judgment. There also it is observed that when the school authority made an application or letter before the DI for seeking permission, and the DI if is sitting idle over this matter, undoubtedly DI cannot pass any order declining to grant the higher scale of pay. In that case, same things has been happened. I made this application. The school authority made forwarding letter to the DI for seeking permission. DI did not do anything, nothing of this sort. Therefore, division bench has hold it. You cannot decline when you are sitting idle. When you have got this letter from the school authority to give this permission, when you are sitting idle over this matter, now you cannot decline to grant the higher scale of pay. These are division bench judgment. Now the special bench judgment, I have also brought this. They are also very clear. Prior permission is not actually required. Therefore, my lord, since all the here my lord, prior permission has been given to me. Therefore, I am entitled to get the higher scale of pay.
Okay.
No, nobody can prevent me. Now, kindly, first of all, you will also consider circular. The circular very, very important. Kindly see the last of all, kindly see the order. This is very important. Kindly see this order. Page 48.
নম্বরটা দিয়ে দিয়েছ এই নম্বরটা রেফার করো 14148
And in this letter, they have admitted that they have issued the prospective permission. They have admitted. Now, kindly see 27 November 2007 circular.
I don't, my humble submission is I have to take instruction from the department. Your lordship, kindly fix it after 2 weeks, your lordship, so that I can take permission with instruction from the department.
Okay.
I can cite 27 November 2007.
Yes. Different idiot will have to take prior permission when you commit any committee.
Page number 1.
This is in 27 next week and the next week. Sunshine.
Probably paragraph 3. Kindly see paragraph 3.
Teacher is equal to seek permission from consent is only mentioned to permission and payment.
বলতে গেলে কি ফালতু
Yes.
Now, kindly see the division bench judgment. 2013 to CHM, page 632.
13
Okay.
632 এটা 2.5
Paragraph 11, 12, 13, 17 and 18. Now I am reading that. Mr. Moitro further submit that the appellant petitioner herein duly applied before the district inspector of Paschim Medinapur seeking prior permission for obtaining the higher qualification, namely postgraduate degree in mathematics. From the records, we find that the secretary of the managing committee of the school concerned, by written communication dated 3rd January 2006, had forwarded the prayer of the applicant petitioner for granting permission to undergo MSc course in mathematics subject. The managing committee of the school so passed a resolution allowing the applicant petitioner to undergo the aforesaid MSc course in mathematics, and this resolution was forwarded to the district inspector of school concerned. Next, the district inspector of school concerned, in spite of receipt of the aforesaid communication, did not refuse the prayer made on behalf of the applicant petitioner or the school authority for allowing the said applicant to undergo the postgraduate studies in mathematics. Paragraph 15. Mr. Mohit also submits that para 3 of the aforesaid circular dated 27 November 2007 cannot override the provision of the West Bengal Control Expenditure Act 2025. 17. It is true that a circular cannot override the specific provision of the Act. In the present case, the applicant petitioner was admittedly appointed in the school as honors graduate with B.Ed degree. As a matter of fact, at the time of joining of the school qualification of the applicant was honors graduate in mathematics and B.Ed. Subsequently, the said applicant appears postgraduate degree. Therefore, in terms of section 14(3) of the West Bengal Control Expenditure Act 2005, applicant herein is entitled to draw the postgraduate scale. Furthermore, para 3 of the office order dated 27 November 2007 has not been specifically violated in the present case, since the applicant has sought for permission from the concerned district inspector of school for undergoing postgraduate study to the managing committee of the school, and such permission was never denied by the district inspector of school. Number kindly see West Bengal Control Expenditure Act, that para 14 subsection 3, page 288. Page 288. Kindly see. There are 14 of the when you obtain the honors degree, he is entitled to get the postgraduate scale. Therefore, 2007 circular cannot override this statute. This is the ratio of the receiving judgment. Now, the special bench judgment, 2025 volume 4 CHM,
Para 182.
page 550,
Para
182 and 184.
বার করে দিয়েছিলাম
180.
182 and 184. The district shall not deny the benefit of the highest profit on the ground to failure to obtain prior permission. And 184 on the paragraph, 184 last 3-4 line is very important.
Yes.
Last 3-4 line is very important. Any teacher pursuing the higher education prior to the introduction of the Control Expenditure 2005 shall be entitled to get post facto approval for a higher scale of pay, provided the managing committee had granted permission and the staff pattern permits to teacher with the higher qualification in the relevant subject. Here, I have got this prior permission. Post facto permission I have got. Therefore, there is no question denying the higher scale of pay. I have made an application prior 2005. The school authority forwarded the letter before the DI sitting idle. DI did not do anything. That's why division judge said that. Now, my lord, subsequently, I got the prior permission, prospective permission. Therefore, DI cannot withhold. Since you have given the prior permission, prospective, you cannot withhold. At 27 November 2007 circular will not be applicable. Insofar my case is concerned. The earth is 27 November 2007 is that prior permission. I have got the permission.
No, no, 182 also says so that if
182
the
also-
managing committee gives the permission and recommends it, the DI cannot. Yes.
My lord, just I'm newly inducted in this matter. This is my first appearance. I'm just praying before your lordship to serve the copy of the writ petition. A direction be passed, and we are going to file affidavit in opposition in this matter, your lordship.
You'll file affidavit in opposition.
My lord, we have to take instruction and have to file appropriate opposition, your lordship.
The ratio is very much clear. Law is very much clear.
That is a chance, fair chance be given, your lordship.
In WPL, we have 14148 of 2025. Similar law was passed.
If they want to put in any affidavit, then they should be-
My lord, kindly liberty be given, your lordship, because we have no idea. No brief is not with me, your lordship, at right now.
But he has served in the office of the government pleader. This has been given. When did
My
you
lord,
serve?
kindly 2 weeks time be given, your lordship. That I will be highly grateful to your lordship.
So Dotto, you give a copy to him.
Please,
Obviously.
deeply grateful, your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for
One thing.
higher scale of pay.
No,
Yes.
one thing. By filing affidavit, we cannot develop. The entire legal aspect, entire of the judgment.
That should not be based a condition. My learned friend is just kindly serve a copy of
Right.
writ
কি
petition.
বললাম? Higher scale of pay. Mr. Dotto, learned advocate appearing for the petitioner submits that the petitioner was permitted by the managing committee to pursue masters in which history? Masters in history. And such recommendation was forwarded to the district inspector of schools AC. Which district?
District, not so sure. Not Telipur. Not Telipur.
North 24 Parganas. However, the district inspector of schools never denied such permission to the petitioner. The petitioner has completed the masters on which year? In which year this has been completed?
2009.
2009. Subsequent thereto, the petitioner applied for getting higher scale of pay, which has been denied on the ground that prior permission was not taken in terms of notification number 593-AC dated 7th November 2007. Although post facto permission has been given to the petitioner on 31st October 2019. Therefore, the rejection on the ground of prior permission does not hold good. He further relies on the decision of a larger bench in UK Coron versus State of West Bengal, reported in (2025) Volume 4 CHN Calcutta 550. And the decision of Honorable Division Bench in Akhtar Hossain Chaudhary versus State of West Bengal, reported in 2013, Volume 2 CHN Calcutta 631. Mr. Brijendra Pratap Singh, learned advocate for the state, seeks accommodation to take instructions. You file a report in the form of affidavit
Not issued.
or report whatever your contention is.
Okay, deeply
You
grateful.
say that you have given post facto permission. Then what is the effect of post facto permission if you again seek for prior permission? That is his contention.
Deeply grateful.
Next week we'll get it.
2 weeks
Coming week.
time, my lord.
2 weeks. 2 weeks of Wednesday তে দেখো কবে আছে কত তারিখে 22 29
Deeply grateful.
it is directed to furnish a report in the form of affidavit on the returnable date. Advance copy be served upon the learned advocate for the petitioner.
29 at the top.
Top 29 দেখে নাও ফার্স্ট 5 এর মধ্যে রেখে
Deeply.
Madam Learned Senior Procedure is appearing for the Madrasa Service Commission. He is arguing in court number 12, my lord. Kindly make it a short passable.
Not today in that case. But only my lord, I have taken out as one supplementary affidavit. Copy mona পেয়েছে না কোথায় না না আমাদেরকে একটা দিয়ে
দেখো ঠিক আছে
না 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 উনি
getting a trained candidates to be given papers over untrained candidates.
ওনাকে দিয়ে লাভ নেই আরে আরে ওনাকে আমি দিচ্ছি আমি
ওটা জিপির কাছে দেওয়া আছে এটা।
তুমি দিয়ে দিও
জিপি সাপোর্ট দিয়ে হবে।
but the short issue my lord, the way that the untrained candidate should be given preference over trained candidates my lord. In connection with the selection process which was of a state level selection test my lord, which was conducted by the West Bengal Madrasa Service Commission my lord, this honorable court directed that the trained candidate should be given preference in terms of the recruitment rules my lord. But the one similar matter went up to the honorable division Supreme Court also. That judgment has been my lord, affirmed by the honorable Supreme Court also my lord. But the one writ petition was filed my lord, that was claiming the similar benefit my lord, that was dismissed on the ground that the petitioner approached this honorable court at belated stage. But against that manner, mandamus appeal was preferred before the honorable division bench. Honorable division bench has held that the judgment has a retrospective effect and the matter has been remanded before my lord. It not in matter in this matter my lord, but in the connected matter my lord, the honorable division bench has directed and জাজমেন্টের কপিটা কোথায় তাহলে ওকে একটা কপি দিয়ে দিই ওরও একটা রেকর্ডে থাকবে এটা দিয়ে দিও না মেমোটার কপিটা কোথায় হ্যাঁ হ্যাঁ সাপ্লিমেন্ট না সাপ্লিমেন্টারি কপিটা এই জাজমেন্টের কপিটা কোথায় গেছে ঠিক আছে আমার কাছে কপি তো কি বলছিল কোর্ট কে নিয়ে ভালো দিকে আগে দেখতে এই পিটিশনারি করেছি তখন কি হয়েছিল কনসিডারে পারি এডুকেশনের স্কুল অসুবিধা না যত এরকম পদবী লোকজন যতদিন না তুলে দিচ্ছে ততদিন উত্তরাখণ্ড তুলে দিয়েছে আমরাও তুলে দেবো হ্যাঁ না না রোজা কেন ওকে অন্য জায়গায় অন্য জায়গায় করিয়ে দেবে
You are trained.
I'm a trained candidate. I'm having the B.Ed qualification, my lord.
This has been listed on which date?
But it is not yet listed, my lord.
My lord, just a short passable. My lord, we will argue.
My lord, in that case, may it come up tomorrow, my lord. কালকে করে দাও বুধবার নেবেন হচ্ছে তাহলে পরের বুধবার যদি সাবজেক্ট
In this matter, affidavits have been exchanged.
No, my lord, it is a fresh matter.
You are not filing any affidavit?
I believe she will not have instructions in that regard.
Oh,
I've just been instructed to.
হ্যাঁ বুঝেছি জি না
in the other matter which has been sent on
It was
remand,
also dismissed at the
affidavits have
motion stage, but the honorable the division bench has directed to file their respective affidavit.
that has been filed.
No, my lord, no affidavit has been filed, my lord. In that matter also, no affidavit has been filed. my lord.
Why?
Before the honorable the division bench, they have used their affidavit, but
No, no, liberty was granted to file affidavit.
yes, my lord, but they did not, my lord. They chose not to file their affidavit.
কবে অর্ডার
Yeah. Accommodation is sought for on behalf of
And
Mr.
my lord, the
Pratik Dal,
supplementary affidavit,
senior
my lord,
advocate.
I'm filing the supplementary.
What is this for?
But the supplementary affidavit, my lord, in that supplementary affidavit, my lord, I have enclosed annexed the orders passed by the honorable coordinate bench, my lord, in the writ petition which was filed by the writ petitioner, my lord, in connection with the selection process, my lord. This selection process, and also, my lord, the IA which, my lord, we have preferred before the honorable Supreme Court, my lord, in the SLP which was preferred by the West Bengal Madrasa Service Commission against the judgment passed by the honorable the division bench, my lord, where the honorable the division bench has affirmed the order of the honorable single bench directing that the trained candidate should be given preference. These facts, my lord, I have
On the prayer of learned advocate for the petitioner, leave is granted to file supplementary affidavit. Supplementary affidavit filed on behalf of the petitioners is taken on record.
but I have served upon the commission, my lord. I shall serve upon Mr. Chatterjee. In course of the day, my lord, I shall serve.
Okay. Learned advocate for the petitioner undertakes to serve copy of the supplementary affidavit upon the learned advocates representing the state as well as commission.
Commission I have already served, my lord.
State.
But, Mr. Chatterjee.
It next year model. Next week another 22nd.
22nd. But there are other connected matters. Those one matter which has been remanded by the honorable division bench, and there are some other connected matters, similar matters. Those matters I am handing over the numbers to my lord's officer. Those matter also.
How many matters?
But 10 matters, my lord, I am told, my lord.
একসাথে করা যাবে
Come on Friday. Mention on Friday. Let it come up. But also you just check whether the affidavits have been exchanged on those matters. If any direction will be required, that will be issued.
Mine.
On Friday, you mentioned, give the numbers. It will come up in the next week.
Mine.
মানে this is 22nd মানে yes আর বাকিগুলো তাহলে মেনশন করতে
Give a notice to the state and then the
state
commission
as well
will
as
then
commission.
mention. We'll put it on that day.
Item 9.
My lord, item 9 also, my lord.
I am on behalf of the petition.
All accommodations are for. This is for affidavits have been filed.
No, my lord. We'll file, my lord. My lord, there may be a direction for filing of it.
Ms. Madhurima Sarkar, learned advocate for the commission, seeks to file affidavit in opposition. Let such affidavit in opposition be filed within a period of 2
There was no direction for filing any kind of opposition, etc. No, this is new. Okay, ma'am. Fine. Okay, ma'am, no issue.
Let such affidavit in opposition be filed within a period of 2 weeks. Reply can be filed within a period of how long will it take to file the reply?
3 weeks may be given for us to file.
3 weeks to file. 1 week you file your reply.
No, ma'am, 2 weeks.
2 weeks. After 5 weeks, this will be listed under the heading hearing. Hearing listed after 5 weeks.
Item 10.
Not
10 is
10
same.
also, ma'am.
Same.
Same matter.
10 is also challenged to wrong questions.
Yes, ma'am.
Yes.
Difficult
Yes,
detection
ma'am.
mark.
Same, huh?
My lord, we are for the state. Lordship
Directed, I have served application upon that.
We are filing our report.
My lord, kindly see for a moment, your lordship's order 22nd April 2026.
Petition 1 is the teacher in charge, 2 is the assistant, 3 is the non-teaching staff. The appointment of the petition was provisionally approved. They will possibly for getting financial assistance. Therefore, I think the honorable was not paid. The petition was paid for use of area of a but is this. So the opposite was allotted, however, the same was not disbursed to the petitioner. The later dated madrasa informed yes.
Yes, and now kindly see, my lord, page 30, kindly for a moment.
Page 30.
Page 30, my lord. The allotment fund, my lord, has been approved. Got it, my lord? 12 June 2023, 25 lakh 84,032. This is date, my lord, 12 June 23, my lord. Now, my lord, it was
25.
impugned order, my page 33, next.
This is correct. This amount
Page
is
30,
correct.
page 30 is correct.
Oh.
This date, my lord, 12 June, my lord, kindly mark it. 12 June 2023. And page 33, my lord, earlier 7 July 2020. That I am paying set aside.
So why the question of rectification? You did not join. Why this has been rectified?
My lord, no clarification is there.
If
Earlier, my lord, this is.
no, you joined on which date?
My lord, 11, page 20, my lord, page 26. Annexure P1, my lord.
1st March 2011.
Yes, my lord.
So your claim of this outstanding honorarium is from which 1st February 2011 to
my lord,
31st November 2019.
31st November 2019.
If
they have issued, my lord, from
approval
16...
is of 1st March 2011, how do you claim from 1st February 2011?
My lord, the approval, my lord, has been, my lord, accord approval, my lord, from 1st February 2011, my lord. Then next page, page 27 is clear, my lord.
With effect from 1st February 2011. Who are the petitioners?
My lord, they are assistant teacher.
One.
My lord. Well, there is 3 teacher.
One. Page 27. One is the petitioner.
My lord, one is the one petition number 1.
Then
Petition number 2, my lord. Mohammed Baki Billah, petition number 2, my lord, serial 2. And petition number 4 in the serial 4, page 27.
no. 3 petitioners.
My lord, 3 petitions.
Okay. So what is your reply to this?
My lord, please come page number 3 and para number 16. Report. রিপোর্টটা যেটা আপনাকে দিয়েছি এটা
Modified. Roma. 16, we know that this has been rectified and changed to 16th May 2016. But why this has been changed? When the letter of approval says that the effect has been given from 1st February 2011, then why suddenly a letter has been issued that the approval should be from 16th May 2016?
I'm grateful.
Once the approval is given from 16th May, the amount that is due is now scaled down. Correct. So claim is from 1st February 2011.
My lord.
What is the reason? Did after the approval you have joined?
Yes, ma'am. We have made application page 28, my lord. Kindly see for a minute. Fund has been allocated, my lord. Where? Tentative to get the surround area.
এটা অ্যালটমেন্টটা পরে এটা কোথায় ওই তো 16 প্রোভাইড
এই যেটা আছে না ফার্স্ট ফোর এই থেকে 1 2 11 থেকে 3 পরবর্তীকালে আমাদের এটা উল্লেখ
In the report, anything has been stated that why this date has been changed, date of approval has been changed?
My lord, kindly a week's time be given. Let's take instruction for that.
There is no any documents.
No,
I have submitted all documents before a lot.
In para 7, paragraph 7 of the report.
Document नहीं कर
No.
An incomplete statement. Sure. You file a further report disclosing the reasons for changing the approval. When a government has allotted the fund, why this was not disbursed?
My lord.
You change the approval and they have discharged their functions as assistant teachers and non-teaching staffs from 11 to 2016. So are they not entitled? There is a government order allotting the funds. Subsequently say that no, these person will get from 16th May 2016 and not from 1st February 2011. So give the reasons for that. What has been stated in the statement is what is the fact stated by the writ petitioner. That we know. The report should be that why this has been changed. Should examine the reasons. If there is rationale, fine. If there is no rationale, then we have to look and examine that.
Sure.
Because they have discharged their functions.
My lord.
Statement of facts filed by the petitioner, furnished by district officer. Copy you have given?
My lord, I have, sir.
No, report copy
Report,
there.
my lord.
Affairs dated 16th September 2025 is taken on record. Para. To the statement of facts records that the staff approval was modified subsequently, giving approval from 16th May 2016 to 30th November 2019. However, the same does not disclose any reason for modification of the date of approval. State, in view of the above, state is directed to furnish, submit a further report disclosing the reasons for change in the date of modification in the date of approval by the returnable date. 29. 29.
Great. Correct.
Item 12.
Well, this is my writ petition. This is the affidavit of service. The petitioner taking a direction upon the respondent authority for disbursing the interest on the arrear, my lord, the salary which was kept pending for years together, my lord. The case of the petitioner is that, my lord, the 2025, the petitioner was appointed as the organizing teacher, my lord. Subsequently, 2011, the said school was recognized. Instead of recognition of the 2011, they have given the approval from the, my lord, 2019. I moved a writ petition before this honorable court. Court given the direction to consider the case. They have rejected my payer. Again, my lord, I moved a writ petition. The last writ petition, my lord, your order passed by the your lordship, kindly see the last order passed by the starts from page 55. And relevant portion is in page 57. Relevant portion accordingly. The reason given in the impugn communication for rejecting the pair of the petitioner for approval of his appointment on and from 1st February 2011 does not appeal to the court. In view of the above, the impugn reason order dated 8 February 2021 is set aside and quashed. The director of Madrasa Education Board, West Bengal, is directed to reconsider the pair of the petitioner for approval of his service on and from 1st February 2011. In spite of my lord, this order, my lord, they have not complied. I moved a contempt application. In the contempt proceeding, my lord, they have again, my lord, issued the during pendency of the contempt application, they issued again, my lord, the region order that has been set aside by the my lord, the Justice Sinha, page 59. Paragraph 3. The stand of the contemner is highly deprecated. The region order dated 21st December 2022 is set aside. In the contempt proceeding, again the same has been set aside. Thereafter, my lord, the next page, page 60. They filed a compliance report stating that the petitioner is entitled for getting the, my lord, the approval from 1st February 2011. Ultimately, my lord, the approval has been given, page 61.
61.
61, page 61. In terms of the course order, approval with effect from, my lord, 1st February 2011. Page, my lord, 61, serial number Samim Islam, Ikka Sampoga, BA Pass, language, date of joining 12th September 2005.
So arrears you have received?
In my lord, they have released, my lord, the arrear. Next page, my lord, page 62. 4,70,968 on and from, my lord, 1st February 2011. So interest should be given, my lord, from on 1st February 2012, 2011.
1st February 2011.
11 from till the date of my actual payment. Payment was made, my lord. Page 65.
Similar problem is facing. In the other matter, the similar problem is facing. I'm asking for the reasons why you are changing it from 1st February to 16th May. What is the reason? The other matter just before this matter.
But in this case, my lord, they have not changing my
No, you face the problem because 16th May was given the approval.
No, my lord.
Yes, yes.
Your lordship kindly see the approval given, my lord, with effect from 1st February 2011.
No, you face this problem.
Yes.
That's why you filed the writ petition earlier.
My lord. The reason is, my lord, there is a, my lord, the circular, my lord, that has also, my lord, I have annexed.
Now you have been given from 1st February.
1st February 2011. Date of recognition.
Ashu.
The institute got recognition.
The affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for disbursement of which authority?
Authority was the district minority affairs office, district officer minority affairs.
Doma.
Doma, my lord.
Or district inspector of schools?
No, my lord. District officer, respondent number 4.
4.
Is the authority.
Respondent for disbursement of interest on
1st February 2022, 16 July 2025.
Honorarium, you are entitled to interest. On honorarium, you are entitled to interest.
Well, it was kept pending for years together on their impugn action. Although I am entitled for approval from the date of recognition, they have not done. Several times I kept before your lordship. Ultimately, my lord, I win. So I also lose her, my lord, economical loser also.
Honorarium from 1st February 2011 to 16 July 2025. The petitioner contains that the petitioner was approved Petition is assistant teacher.
मतलब the petitioner শিক্ষা সম্প্রসারক designation is শিক্ষা
Appointed,
সম্প্রসারক
appointed as Sikha Sampracharak in what is the name of the madrasa?
মাদ্রাসা my lord
In Kamalpur Junior High Madrasa in the year 2003.
no my lord
common law
Hold on. You were given appointment on which date? No, I joined on 12 September 2005. No, joined. 2005. 12 September 2005. 12 September 2005.
and the Saint madrasa was converted as শিক্ষা
The said madrasa got recognition in which year?
my lord in the year 2011 my lord I have annexed my lord.
With effect from 1st February 2011. At first, the approval of the petitioner was made on and from 16th May 2016. However, subsequent to orders passed in the contempt writ petition and contempt petition, writ petition number WPA 19656 of 2011 and WP contempt application being WP CRC 17 of 2024. The approval of the petitioner has been given from 1st February 2011. The arrear of honorarium has already been disbursed to the petitioner on which date?
Disbursed my lord on my lord 16 July 2025.
16 July 2025. However, no interest has been paid, hence this writ petition. Baki same 8%, 8 weeks. From 1st February 2011 till 16th July, no?
Right.
This will be July 2025.
Right.
Disposed of.
Right.
Leaves the matter to the discretion of the court.
13 also my lord the same madrasa institution, same order my lord that I have already annexed. Page 59 if your lordship in the page 59.
59, yes.
MD Kafil Mondal in the same memo my lord the approval has been given from 1st February 2000.
That was Samim. The other was other writ petition Samim.
Samim my lord.
Same order.
Same order. When the date of my lord, the payment also my lord.
1st February 11 to
This.
file din.
Yes, my lord. 16 July 2025, my lord.
Sure.
Page 62.
Oh.
Yes, sir. Grateful.
Yes.
What the petitioners are the teaching and non-teaching staff of the respondent madrasa, my lord. The
Deficit court fees paid? Yes, paid.
I have to check up my.
Yes, it is paid.
This way.
Yes.
But the petitioners are the teaching and non-teaching staff of the respondent madrasa, my lord. They have been working for a long considerable period, my lord, and they are similarly situated persons who have also filed writ petition before this honorable court, my lord, praying for approval of their service, my lord. My lord, in respect of them, my lord, this honorable court directed the page 40 is the order passed by this honorable court, my lord, directed the district inspector of school to approve their appointment, my lord, and pursuant to the direction of this honorable court, my lord, they have already, my lord, the district inspector school has approved their appointment, my lord. Page 44, my lord. We are also praying the similar benefit, my lord, as has been passed by this honorable court, my lord, by the judgment and order dated 28 June 2017, my lord. We are the similarly situated persons, teaching and non-teaching staff, my lord. But our appointment letters, my lord, page 16 onwards, our appointment letters, my lord.
Page 16.
Yes, my lord. And thereafter, my lord, our joining report also, my lord, I have annexed. And I have effected fresh service upon the state, my lord. No, but
Madrasa, you have, sir?
But I have annexed, but I have implemented, my lord, the respondent madrasa, my lord, as a party, my lord.
Service upon madrasa?
But the affidavit of service, my lord, on the first day, my lord,
First day you have filed affidavit of service that of upon state. Yes, Secretary Madrasa. Yes.
my lord.
State.
I don't just we have to receive the petition from the department, your lordship, but praying 2 weeks time to file instruction.
My lord, yes, my lord, we also filed one application before the honorable coordinate bench, my lord, page 48, my lord. My lord, for addition of party, my lord. Page 48, my lord, can 1 for intervention, my lord. This direct, my lord, the granted us liberty, my lord, to file, my lord, the appropriate application, my lord. But the petitioner is still discharging their duties, my lord, which is perennial in nature, my lord. Therefore, my lord, the petitioner, the service may be approved, my lord. And my lord, we are similarly situated like the
State. But in terms of order dated 6th May 2026, Mr. Anindo Bose, learned advocate for the petitioner, submits that in terms of order dated 6th May 2026, service has been effected upon the state. State 6, Mr. Brijendra Pratap Singh, learned advocate for the state 6, to file a report. Let such a report be filed within a period of 2 weeks. Only state is the answering respondent.
At the DI, my lord.
DI. Within a period of 2 weeks. After 2 weeks.
Yes.
You'll file any exception to the report or?
But if they file, but liberty may be granted, my lord, within, my lord, the
1 week করে 3 weeks পরে তাহলে লিস্ট করে দাও।
but advance copy may be served so that, my lord.
3 weeks করো।
Great.
2 weeks and 1 week.
না, copy নেই দাদা। My lord, I have to serve a copy, my lord, to my last friend.
On the prayer of learned advocate for the state respondents, let copy be served upon the state respondents. Next week then? This matter. Coming week again. What is, wait, Mr. Ganguly? What is the prayer in the writ petition?
Prayer, my lord, here, my lord, my lord, there was a, we are from the, my lord, appointed under the madrasa, my lord. My lord, thereafter, there was a second SLST, my lord, came, wherein, my lord, 10% marks was granted, my lord, as per experience of the teacher, my lord. So, my lord, at that point of time, my lord, since we, that portion, my lord, the appointment of the petitioners were not affirmed, several cases were there before this High Court, my lord, it went up to Supreme Court. My lord, Supreme Court, my lord, ordered in our favor. Yes, you are a regular teacher. My lord, that 10% marks, my lord, if we can put that 10% marks, then there, my lord, is
Then the Madrasa Service Commission is not a necessary party in this?
yes, we have served, my lord.
But I find that in the respondents, it is.
Say, before they go. We have served, my lord, if your lordship is, I can serve any.
So Madrasa Service Commission is not a party.
My lord, come. My lord, this relates to, my lord, the West Bengal School Service Commission. Madrasa, my lord, they have no role to play, my lord. I have annexed, my lord, certain judgments, my lord, wherein, my lord, our appointments were, my lord, allowed by the High Court as well as the Supreme Court. As such, my lord, we are, my lord, can get the, my lord, 10% marks on the experience, my lord, point, my lord. That I have, my lord, asked here. If your lordship says, my lord, I can add him as the party.
It's not required because you have appeared
Yes.
in terms of the second SLST by the West Bengal
That is
School
why
Service
I
Commission.
didn't make party.
Okay, let it appear to next week of service to us. See.
16.
Lordship, I am led by Mr. Devashish Banerjee. He is engaged in courtroom number 1. Lordship, I am praying for a not today.
Lordship,
Regulation of his employee group D.
Lordship, I would require Lordship, if Lordship may kindly allow me 2 weeks time to take the necessary instruction. Even also Lordship that if your Lordship may kindly consider the prayer, they are praying for Lordship direct appointment in the vacant post of Group D staff, Lordship, which is now presently lying vacant in the concerned madrasa.
You have served upon
Whether
the
that is
Madrasa
permissible?
Service Commission.
Yes, Your Lordship.
Where is the affidavit?
Lordship, kindly give the adjournment. I don't have the file with me.
Lordship, kindly allow us to file the instruction.
Affidavit of service.
এই মামলাটা নয়।
দেখো তো ইয়ে আছে কিনা মধুরিমা সরকার কোর্টে আছে মধুরিমা সরকার You are appearing for board?
I'm appearing for the state of West Bengal, Lordship. That board, Lordship, that.
Next week is that up. On the prayer of learned advocate for the petitioner, leaves this matter. Next week.
22nd July. Great.
Not after the petition. What you can recollect. This matter my lord, pertains to a settled situation which is no more res integra. The petitioner my lord prays for the postgraduate scale of pay my lord in working in the madrasa. So my lord, the context in this matter was while he was my lord pursuing the postgraduate my lord degree, my lord, he was appointed. While he was pursuing, only 10 days were left for the purpose of my lord the finalization of the examination. So after she was appointed, my lord, she completed the examination. Now, my lord, she is the second condition that she is engaged in, my lord, honors graduate post itself, which means, my lord, because the subject is nutrition, so which is only there for the 11 and 12 classes, not in any other classes. So it is meant for honors graduate. So, my lord, these two criteria have already filled. Now, my lord, I am covered by the judgment of this honorable court, which says that if these two criteria are filled in that event, I am entitled to get the postgraduate scale of pay. On the completely, my lord, contextually same situations, the judgment is passed.
Pursuing. You completed your part 1.
I completed my part 2 as well. My lord, part 2 examination was only left, which was after 10
Part
days.
1 you have
after
completed.
Part 1 I was already there.
This in which subject?
My lord, nutrition.
Nutrition.
On the same subject.
Your prayer has been rejected.
Not rejected, my lord. It is still, my lord,
Pending.
Pending. Pending since 2013.
13. The writ petition was filed.
Yes.
After so long, you have not been granted.
But I have not been yet. My last representation my lord, has been made in 2024, which is at page 52. No. Page now 46, my lord, which is 24 June 2024. দেরি স্বার্থ গেছে প্রিন্ট করে নি সরকারের পয়সায় ঠিক আছে পেয়ে গেলে রেগুলারাইজ করি
Yes.
I know. The last prayer, my land is senior myself. There are two district inspectors who are parties before your lordship. Because of the reason, when I was engaged, my lord, I was under a different district inspector. In this meantime, my lord, I was transferred and am posted in the other district inspector. So, my lord, this is why two district inspectors are party. So, my lord, the previous district inspector will be the determining, my lord, authority who will be determining my postgraduate scale of pay, and the present one will be the disbursing officer. So, your lordship will see 4 is the district inspector where I was engaged, and 5, my lord, is the present district inspector.
The commissioner will decide that.
I shall.
District inspector of both the districts will come under
They are
commissioner.
under absolutely. Well, in that event,
my learned friend, senior friend, has just assured us to serve the copy today itself, your lordship, and we are praying 2 weeks' time to get instruction from the department, your lordship.
What instruction? There is judgment of this court. Again, you'll file a report.
No, just get instruction.
হ্যাঁ, যদি কনসিডারেশনে পাঠায় তখনই তো হয়ে
Your
যাবে।
lordship may be sent for the consideration of the commissioner.
But in that is, yes, in that event, I'll just pray only one thing, Your Lordship. Since this issue is no more res integra, if Your Lordship sends me for consideration, kindly let it be done, my lord, in the light of this. Or, my lord, if my lord comes to Your Lordship with the instruction, it could be disposed of, then that will be perfect for me.
My lord.
There will be no consideration, my lord, that will be.
That will.
And also find out from your client whether in the meantime any orders were passed for rejection or not.
No, I would have, my lord, annexed.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly District Inspector of Schools, Murshidabad, to grant postgraduate scale of pay to the petitioner from the date of attaining the master's degree in nutrition, and also pay the arrears together with interest. The petitioner contains that she was pursuing postgraduate qualification at the time of joining the service. In which year she joined on?
But I tell you, Lord, in 20, page number 79, which would be, my lord, 22nd of June 2011, my lord. The
22nd June 2011.
So that was the recommendation. The next page, Your Lordship will see the appointment letter, and the next is the joining.
No, date of joining is 22nd June.
No.
18 July 2011.
That would be, my lord, 18th July 21.
18 July 2011.
Yes,
11. Upon completion of the Part 2 examination, the petitioner made representation. No. And the results were declared on which date? MSc Part 2.
Page number 30 is the certificate. Page number 28.
Okay. After successful completion of the Part 2 examination, the petitioner made a representation before the concerned authority, seeking for higher postgraduate scale of pay in the year 2013.
First 2013. Successive representation.
However, no steps were taken. Ultimately, on, please tell me the date of your representation. 24th June
2024, man.
2024, the petitioner once again made a representation seeking for postgraduate scale of pay. However, the same is still pending consideration, hence this writ petition. Mr. Brajendra Pratap Singh, copy you have given? Copy?
Yes, madam, yes. Copy, I'll be just
Brajendra
giving
Pratap
the
Singh,
course of
current
the
advocate for the state respondent, seeks to take instruction. Or you file a report?
But as
File a
the
report
entitlement of the petition.
with regard to the entitlement of the petitioner.
Grateful.
Release this matter after 2 weeks. Within a period of 2 weeks, release this matter after 2 weeks. Any.
Okay. May I just request, madam, let this matter retain its position before this. So grateful to you.
18, I am for the petitioner, my lord. This is the affidavit service. After change of government, I also served to the GPO, my lord. This is compensate ground. My lord, this is compensate appointment, my lord. Died in harness category, my lord.
Rejected?
No, my lord. No action has been taken till now, my lord. Actually, in this matter, my lord, the father of the petitioner was the approved head teacher of a madrasa, my lord. On 9 June, my lord, 2026, he missing, my lord. Thereafter, my lord, on 13 June, the elder brother of the petitioner filed a missing diary. Thereafter, again, filed a missing diary on 3 and 2 time, my lord. Thereafter, the school authority managing committee also take a resolution that in place of the headmaster will take the teacher in charge. That resolution are also annexed in this petition, my lord. Thereafter, till now, my lord, now police take any action regarding my father. nor the DI will take any action to appoint me. This matter is pending.
So what is the rule? How do you get the compassionate appointment when a person is missing?
Yes, my lord.
Is there any rule that a person, if an employee has went missing, then will be considered for compassionate appointment?
My lord, if the police authority given me not traceable certificate, if this not traceable
Where is that
certificate,
rule? Where is that rule?
there is no any particular rules, my
So
lord.
they will give you compassionate appointment beyond this scope. Show me the rule. It's a died in harness.
Yes, my
The
lord.
person has gone missing. Is there any declaration of the court that after this period he has been declared as a
My lord,
person dead?
my lord, this is considerable appointment, my lord, and my lord, after 7 years already it is resumed that the who are missing and who are not found, my lord, that is death, my lord.
Show me that rule. Show me the rule.
My lord, give me some time, my lord. Take it after 1 week, my lord. I will try to bring them in. Now I have no.
By the present writ petition, affidavits of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for appointment on compassionate ground. Mr. So and an advocate for the petitioner submits that the father of the petitioner, namely, what is the name of the father? Anwarul Islam.
Anwarul Islam, my lord.
While in service, has gone missing since 9 June 2006 and could not be traced. Subsequent thereto, the petitioner, on which date you find that?
Yes, my lord. The petitioner made an application on 8th July 2025, my lord.
8th
July 2025.
8 July.
At
8 July, yeah. On 8 July 2025, the petitioner made an application
page 25, 24.
for appointment on compassionate ground before the District Inspector of Schools, Balurghat, Dokhin Dinajpur. However, no steps have been taken, hence this writ petition. State is directed to furnish a report on the returnable date, place this matter of 2 weeks. Give a copy to
I will just
next copy to
সাব করে দিয়েছি তো অফিসে জিপি অফিসে নতুন করে
Matter relating to my lord, interest on gratuity and arrear pension in respect of revised PPO, my lord, ROPA 19.
ROPA. Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for disbursement of interest on gratuity and arrear pension. Revised gratuity and arrear pension with effect from the date of ROPA 2019. So we need to pore deben ekhane effect of ROPA থাকে the petitioner contains that he was appointed as when did he join?
My lord,
It is joined as an assistant teacher in High Madrasa School on
Talbang.
On which date you joined?
To us. That's not mentioned, my lord. I
Was an assistant teacher, retired colonel. The petitioner retired as an assistant teacher of
31st December.
Talbang Grua.
Yes, my lord. Talbang.
Talbang Grua বানানটা ভুল আছে Talbang Grua High Madrasa Police Station Horishchandrapur District Malda on 31st December 2017. The first pension payment order was issued on 9th March 2018. The revised pension payment order under ROPA 2019 was issued on 14th March 2022. The revised gratuity and arrear pension was disbursed to the petitioner on 16th March 2022. However, no interest was paid, hence this writ petition. Rest same with effect from 14th February 2020. 8%, 8 weeks. Disposed of. Leaves the matter to the discretion of the court.
I'm good.
My lord, I appear for the Madrasa Service Commission.
I am appending to petition. My lord, I want to draw your fine attention. My lord, first, my lord, the list of date, my lord, this is the, my lord, very important. Two list of date. One.
Yes.
My lord, preliminary screening case held on 28 November 2010, and thereafter examination was held appeared. Petitioner appeared examined to 27th March 2011, and result was published 12th September 2024. The 25th September 2024, Respondent Authority concerned appointed the date of interview for the post of Group D. 18th July 2025, Respondent Authority concerned asked the petitioner to appear in counseling. And 25th July 2025, one of the MPNL candidate was recommended for the post of Group D. And 7th September 2025, the said candidate died. Sabirul died.
Now died malot ke after malot ke 2 months. And on that date malot petitioner by the waiting panel candidate waiting list number 1. Malot the waiting list malot ke not malot by mistake malot ke not the annexed malot.
No, it is number 1.
Number waiting
No
list.
problem.
And petitioner made a representation. Well, I am the waiting number list 1. When the malot ke the appointed candidate within a few months died, I made a representation. If the malot the
Yes.
you can permit malot kindly malot consider. This is the malot respectful submission.
Malad, may I? Malad, only 2 things are required here. Thing number 1 is, can you take malad paragraph 8? 2 paragraphs, and that is the everything entirety of the matter. Can you take paragraph 8? Paragraph 8, my lord, kindly see last 4 words. He joined on 25th of July 25. So somebody who is selected, he joined. So it's a clear admission, that's true. After someone joins, he dies. Question is, if he dies, pre-joining, there is a one kind of mechanism for which there is a waiting list. But if someone joins and dies, say after 1 month, 2 months, whatever, then whether the same mechanism can be used, in a sense, this is a reservoir for the waiting list, can it be used? That question has taken up by the Honorable Supreme Court. Unfortunately for my learned friend, the Honorable Supreme Court have held, once someone joins, my lord, that reservoir for the waiting list cannot be used, because then it becomes a new vacancy for the new recruitment. That's 2 judgments. Kindly take, it's a 2025. This is the crux of the entire matter. There is nothing. I understand. 2025 SEC Online, Supreme Court 2243, paragraph 12. Now, may I place it? While considering the entitlement of the respondent to any relief on the basis of his placement in the reserved panel, it would be necessary to bear in mind the settled position that mere placement in the wait list does not create any vested right for being so appointed. The right to be considered for appointment would spring only in the contingency of a selected candidates, thereafter 4 words, not joining on his post. So it is, I have shown is the admitted case, he has joined, because but otherwise it will have a spiraling effect. Okay. And also kindly see paragraph 13. Paragraph 30, yes, this is, so if I have read it. 13, my lord, the lordship may skip the 13 first paragraph, take this next paragraph starting from the words for considering. The binding nature of such statement made before the tribunal, certain factual aspects would have to be borne in mind. Though the placement of the respondent was at serial number 1 in the reserve panel, the similar thing, he was number 1 in, all the selected candidates had joined on the post of technicians, and thus there was no occasion to operate the wait list as an admitted position. No vacancy for 97 was carried forward, and a vacancy, if any, that was to arise in the future, which is the case, would have been a fresh vacancy. The entitlement of the respondent, if any, was as a waitlisted candidate qua the select list of 97. There was no vested right thereafter. Yes. And the words, if lordship ending of the last sentence I was reading, that there was no vested right in favor of the respondent to urge that he was entitled to be considered an appointment on any fresh vacancy arising in the future. So the point of law, as Miller clearly decided, arising in the future means if it is a pre-joining, it is not arising in the future. But the moment someone joins, Miller, it goes for the future. There is one more judgment there. This is 2010 2 SCC. 2010 2 SCC 637. Now this is the earlier one, the usual, the two judge bench. This was the larger bench of the Honorable Supreme Court. Now, paragraph 8 to 13, practically quoting some others. Well, I'm not reading its entirety. Lordship may kindly take note of paragraph 8. Paragraph 8, my lord, this wet list prepared in an examinations conducted by the commission does not furnish a source of recruitment. It is operative only for the contingency that if any of the selected candidates does not join. So there is, my lord, a very, very mathematical, I would say, distinction. A line is drawn, pre-joining and post-joining. This is clearly case of post-joining. Unfortunately, he doesn't have a case. But these are my respectful submissions.
By the present repetition, the affidavits,
My lord.
Affidavit of service and on behalf of the petitioner is taken on record by the present writ petition paragraph. The petitioner seeks direction upon the respondent authorities to consider the prayer of the petitioner for appointment in the post of peon of Ranaghat in Fakir Muhammad Madrasa, High Madrasa, herein after referred to as the said Madrasa, comma, subdivision Ranaghat, district Nodia. The petitioner contains that he was the first west-listed candidate for recruitment of Group D peon in different madrasa schools. The person, namely Sabur Ali Biswas, who was recommended for appointment, joined on 25th July 2025. However, subsequent thereto, he died on 7 September 2025. The petitioner seeks that his appointment, that he be permitted to join as Group D from the waitlist panel. Mr. Swensu, learned advocate, appearing for on such and such date. On which date you made application? On 1st November. What is the date of your representation?
Date of representation, my lord, 1st November.
On 1st November 2025, the petitioner made a representation seeking for appointment. However, the same has not been considered. Hence, this writ petition, Mr. Swensol, an advocate for the petitioner, submits that the petitioner should be granted appointment since the candidate who has joined has already died on 7 September 2025. Mr. Pratik Dhal, an senior advocate appearing for the petitioner, the commission, submits that once a person joins, the waitlist candidates could not claim any right to be appointed upon the death of such person. The vacancy goes to the future recruitment process as a fresh vacancy. To buttress his contention, he relies on the decision of the Supreme Court, Act 2025 or 2010. Upon hearing the learned advocate for the petition, respective parties, the only issue which falls for consideration is whether the petitioner can be granted appointment in the event of death of the candidate who has already joined prior to his death. In order to examine the aforesaid issue, it would be opposite to reproduce the relevant observation of the Honorable Supreme Court, para 12 set out later. Or it was para 8. Bearing in mind the aforesaid proposition, as laid down by the Honorable Supreme Court, the petitioner has no right vested on him to claim for appointment upon death of a person who has already joined in the post. According to the petition falls out of merit, dismissed. Tell me. Law means.
I'm appealing for the appellant. My lord, the original appellant has died. The legal heirs have filed a substitution application which is pending, my lord. It is filed in time.
I am for the respondent, my lord.
Can to Can? What?
Can 6815
Six,
of
eight,
2009.
Oh, see, old can.
Old can, my lord.
Copy you have given.
Yes,
Yes, my lord.
one copy has been served upon me.
6815.
Six eight one five of 2009.
And the other number, other is?
T28. My lord, in this matter, in SA 328, no substitution application has been filed. Only in 327, substitution application has been filed, my lord. My lord, 327 and 320 analogous matters. I'm holding a transfer brief, my lord. I couldn't find out any substitution application in connection with SA 328. My client's instruction is we shall not file any substitution application in that matter because we are not interested in that matter.
328.
328. So, my lord.
328. And this is 327.
327.
Death certificate.
SA 328 has already abated as no substitution application has been filed. So, SA 327.
Kindly record that, my lord, submission of regarding 328.
I need not make any submission in connection with 328 because it is already abated. If they file any setting aside abatement application in future, they will think of.
That is their. No.
They are in 328.
328 is filed by respondents.
No, by the appellants.
Okay.
By the appellants. So to emni abate kore geche ami ar ki submission korbo. SA 327 is
Kindly record that it has been abated, my lord, regarding 328.
it may be recorded that it is abated.
And it is within time, my lord.
27.
327.
Who has died?
It is within time, my lord. Kindly allow this.
No. Who has died?
But the only sole appellant, my lord, Lakshmi Narayan Pal Chaudhary. Lakshmi Narayan Pal Chaudhary, sole appellant.
July. Any death certificate you have?
The death certificate has not been annexed. I have the copy, my lord.
Give that.
Lordship may kindly see this.
Can 6815 of 2009. This is an application for substitution of legal heirs of deceased appellant Lakshmi Narayan Pal Chaudhary. Huh? This can has been renumbered.
My lord?
Can has been renumbered.
No, my lord. It has not yet been renumbered, my lord.
Days list treat ko.
2 या 3 ही तो दिखलाम substitution আর কোন application number দেখলাম না
এগুলো হয়ে গেছে
it has 6815 of 2009.
অত পুরনো দেখাবে না অত পুরনো দেখায় না
No can. আসবে না
ওরা হয়তো পুট করে
what did you get to 24.
আগের দিন অর্ডারে বলা আছে, আগের অর্ডারটাই বলা আছে।
কেন আসবে
বলুন না, আগের দিন অর্ডারে বলেছিলেন তো।
সেটা বলেছে, ওটা না।
কেন লিস্টে আসবে না ওটা?
নতুন নাম্বারটা দেখাচ্ছে কিনা ওইটা নাম্বার কিছু দেখাচ্ছে।
এটাই তো, একটা নতুন নাম্বার না পড়লে তাহলে কি করে হবে?
Then 1 of 2009 বোধহয় লিস্টে আসেনি, কিন্তু আছে ওটা।
নেই নেই নেই,
ওটাই এক
1 of 2009 বলে কিছু নেই। হ্যাঁ, কি করবো তাহলে, এটা দেবো? ও, মানে এটা আমি বলেছিলাম বলে দিয়েছে ক্যানটা। আচ্ছা, Miss Ghosh, I am placing the matter next week. The can has been received but not listed. We just find out from the department why it has not been listed in the, huh?
My.
Otherwise, if he pass the order, he cannot upload the order.
My.
So this is the difficulty. So just make it not today. Next week I'll take it up.
মানে the death certificate
Yes. এটা চেক করে নিন, নেক্সট উইকে তাহলে ওপরের দিকে রাখুন। We check it. Next week we'll take it.
Fine. 65 minute I am for the petitioner.
Yes.
But it is that matter which was in August 2025 it was disposed of. For some correction, I mentioned the matter and it was came as to be mentioned. And on that day, the state respondent again made submissions and they filed 2 reports. And on the basis of their submissions, manner, your lordship was recalled your lordship's order and fix it for further hearing, manner, a fresh hearing, manner. Now it is
There was an order of the appeal court which says that if there is any criminality in the aspect, that should be inquired into.
that part, yes.
Only that.
Since that was not discussed or not submitted, the order was recalled and
That issue, they made submissions, my lord.
My lord,
And thereafter they filed 2 reports, my lord. The same video filed the same report which they have filed earlier, my lord. And this is the second round of writ petition. In first round of writ petition, this honorable court directed the principal secretary to consider the representation and look into the matter whether the petitioner is at all eligible or entitled to get the money as due in his favor, madam. There, after hearing of the petitioner and all the respondents, madam, the district magistrate hold that the petitioner is entitled to get the residue amount which he entitled to as per the work order issued by the executive officer, madam, of the Panchayat Samiti. Thereafter, madam, the DM directed the concerned respondent to allot the to disburse the amount in favor of the petitioner. Thereafter, the respondent, the concerned respondent, he wrote several letters to the concerned district magistrate for allotment of fund. As subsequently, fund was allotted and some amount of money disbursed to the account of the petitioner. But still, some amount is due, and for that due, my lord, this second writ petition preferred by the writ petitioner. And
14 lakh something.
yes, my lord, this is the last residue amount due in favor of the petitioner. And
Now, what is the aspect of any criminal filing which is
yes, my lord,
in MAT?
before the erstwhile single bench, my lord, when the matter was first time taken up, that time a random submission made by the state respondent that no due is pending in favor of the petitioner, all money has been given, a false representation he has made, and this petition falsely made. And when all the documents are there, the what is the actual due and how much was paid after the order of the district magistrate pursuant to the order of first writ petition, my lord. And on that submission only, the honorable court at that time passed the order to process criminal proceedings or to initiate a criminal proceedings against the petitioner. That order was questioned in an appeal. The appeal court set aside that part to initiate any criminal proceedings against the petitioner, but at the same time the appeal court directed the single bench to look into afresh about the matter, the whether any possibility or anything is there to initiate any criminal case against the petitioner. Only that much was there, madam.
After the recall of the order, the report has been filed.
Yes, 2 reports have been filed, madam. Everything I have served upon the state respondent.
My lord, I am for the state respondent and I am nimbly engaged in this matter. And I have communicated with the DM and principal secretary all this, but they have told that no proceeding has been initiated till now. So, my lord, please give me 2 weeks time for filing the report.
But already report filed.
Already report
A
is there.
detailed report,
No,
not
after
only
that
one,
order,
my lord,
no,
twice report filed, both
pursuant to
before the single bench and the division
order,
bench.
28 August 2025, no report has been filed, my lord. All the report before that, prior to that order, and your lordship's order, I think no report has been filed. I'm not sure because I have
No,
not
no,
given.
no, no. I have
I'm not
served
served
the
with.
When was the order
reports I have
of
served.
recall passed? When?
They are on that day, my lord, they filed 2 reports. One
28 August
filed by the
2025.
DM and another is for the BDO.
Video. That I know. Yeah, they have
Those
told
2
me.
reports I have already served upon them, my lord.
File a report here. Pursuant to 28 August 2025, any report has been filed?
No, no, my lord, no.
Where is that?
The division bench, they have filed report.
No, no. When the order of
Pursuant to the
recall was
order,
passed
no.
by this court,
No, the
after
first-
that there was a direction to file a report regarding this criminal any complaint has been lodged or not.
That report filed.
No report has been filed pursuant to the order dated 28 August 2025. Because today I have communicated with the BDO told me
Well,
till
this
now no
report on
report has been
12th of
filed.
September 2025, one report by the executive officer.
Hmm.
That is 12th of September after the order of recall. My lord. Recalling order was
August.
2025. Thereafter this report filed and the DM's report also filed on the same date, my lord. All the reports are.
We don't have all this.
আমি দিয়েছি আপনাকে দুটো রিপোর্টের কপি দিয়েছি।
শোনো না, আমি তো নতুন ইংলিশ, আমাকে শুধু
সেটা তো বুঝতে
solution টা
পেরেছি,
দিয়েছে।
এবারে ওরা যদি না দেয় আমরা কতবার
না,
দেবো বলুন
না,
তো? আমি চিঠিতে
আমি-
ওই জন্য লিখে দিয়েছি
শোনো,
যে কি কি
আমি
দিয়েছি।
জেরক্স করে নেব, টাকা দিয়ে আমি জেরক্স করে নেব।
কিন্তু আমি
তোমার কাছ
দেখো,
থেকে
ওই কারণেই আমি চিঠিতে লিখে দিয়েছি যে আমি কি কি
দেখেছো,
প্রোভাইড করছি।
কিন্তু ওরা তো আমাকে দেয় না। আমি তোমার কাছ থেকে যদি প্রয়োজন আমি
কারা দেবে?
করে
আমি
নেব।
তো জিপির অফিসে সার্ভিস করেছি, আপনি জিপির অফিসে জিজ্ঞেস
জিপি এসে গিয়েছিলাম, দেখা হয়নি, কি করবো, মামলাটা উঠে গেল। আমি তো কিছু
মানে দিস ইজ ভেরি আনফরচুনেট।
দেখা হয়নি তো, আমি তো মামলা তো এসে গেল, আমাকে তো বলতেই হবে। জিপির অফিসে অপেক্ষা।
এই 12 সেপ্টেম্বরের রিপোর্ট এখানে নেই কেন? দেখো অর্ডার করেছিলাম 12 সেপ্টেম্বরের রিপোর্ট ফাইল করেছে ডিস্ট্রিক্ট ম্যাজিস্ট্রেট, কপি সার্ভ। এই রিপোর্টটা কোথায়?
হ্যাঁ আছে তো, সব রিপোর্টই আছে।
হ্যাঁ, ওর কাছে তো আছে। এই কোর্ট থেকে
স্টেটমেন্ট অফ ফ্যাক্ট রিপোর্ট না? ইয়েস।
দিয়েছি না রিপোর্ট, দেখুন আমি লিখে দিয়েছি কি কি দিয়েছি। মুশকিল বলুন তো, সব এই জন্য আমি লিখে দিয়েছি দেখুন। দ্য রিপোর্ট ফাইল বাই দি রেসপন্ডেন্টস।
ওই পিটিশনটা দিয়েছে। What can I do? That's why I am
পিটিশনার
এই দেখো না, আজকে করেছি, এই দেখো কমিউনিকেশন টু দ্য প্রিন্সিপাল সেক্রেটারিকে মেইল করেছি আজকে, ডিপিএলকে করেছি আর ডিস্ট্রিক্ট ম্যাজিস্ট্রেটকেও করেছি। তো তোমার ক্লার্ককে দিয়ে আমি টাকা দিয়ে একটু জেরক্স করে আনতে পারবো কি? জিপির অফিসে যাওয়া মানে আর বসে থাকা, আর 15 দিন বসে থাকা, এদিকে সময় চলে আসবে। ওরা কোথায় দিবে? কাল তো দিত, দেয়নি যখন কোথায় পাবে? আমি বলছি আমি টাকা দিতে জেরক্স করি ওর ক্লার্ককে দিয়ে, যদি দেয় আমাকে। মনে হয় না তার তো দিত শুধু পিটিশনটা দিচ্ছে আর কিছুই দেয়নি ওকে দেখা তো পাই না আমি গিয়েছিলাম দেখা করতে দেখা হয়নি নেই আমি আমার নিজে থেকেই আমি করি ওটা দেখা দেখি কন্ট্যাক্টটা ঠিক আছে আমি এটা জানাতে হবে
You have the copy of the report dated 12 September.
12 September. My lord.
Are you carrying the report dated 12 September?
No, my lord.
It is not with you. In paragraph number 10 of the report, they say that the executive officer has issued a show cause notice against the petitioner. In para 10. Now this memo has been quoted. The inspector in charge of Muhammad Bajar police station has also been served with that. What is the steps taken? Any criminal contempt was lost.
What can I do, my lord? My lord, please.
No, this was
Only
initiated
1
prior
week time. Then I will go through this report. I will take one copy from her. Then I will again later and please only.
This was initiated prior to the order of the division bench.
Which one?
This show cause notice. This is only a show cause notice.
No, this is after. The memo is dated 10th December 2024.
Yes.
And the order has been passed on 29 November 2024.
Yes, thereafter, and the division bench order in January 2025.
January.
January 2025. It is in February 2025. This is the order of the division bench.
Yes. By order dated 28 now. This writ petition was disposed of on 18th August 2025. However, upon submission of the learned additional government pleader that the liberty was granted to the state authorities for filing criminal complaint, which was not been submitted by the petitioner at the time of disposal of the writ petition. The order dated 18th August 2025 was recalled. By the said order, a report was called for from the state authorities as to whether any requirement, if there be any, of filing criminal complaints against the writ petitioner. In its report dated 12 September 2025, the executive officer Muhammad Bajar Panchayat Samiti, Birbhum, has stated that a so-cause notice was issued to the petitioner, which was sent to the inspector in charge Muhammad Bajar police station. The advocate for the state seeks accommodation to take appropriate instruction regarding filing of any criminal complaint against the petitioner. একটু নেক্সট উইকে রেখে দিন, ওপর দিকে রাখবেন। Same matter. 22nd. You take instruction whether there is any criminal complaint filed against the petitioner. That is all. 22nd.
Order sheet টা কোনটা?
22nd.
May I come back with a detailed list of dates or
You can give, you have given a detailed list.
regarding all the thing before the single bench and the division bench,
Okay,
everything
give-
with the
give-
orders? I'm grateful to you.
Next.
In this matter, Lordship, I am appealing for the state. Lordship, I am praying for one more week accommodation, Lordship. Kindly,
Tell me when you are going to argue the matter.
This has been going on.
Lordship, kindly fix on next Friday, Lordship. I shall come with the Lordship.
These are
Not on Friday. So making it not today, let it come up in the next week.
I shall.
You go through the records.
I shall, Lordship.
All pleadings have been served on my time.
শুধু
এটা not today করে রাখো।
এই পিটিশনের রিটের প্লিডিংস গুলো দেননি।
হ্যাঁ, লিস্ট করে দিয়েছি।
নেক্সট উইক
লিস্ট করে দেখিয়ে দেওয়ার জন্য।
হ্যাঁ হ্যাঁ সরি ঠিক আমি পেয়েছি।
I apologize for making this submission, my lord. I beg to appear for the, my lord, the applicant, recalling application applicant, my lord. I'm just seeking for a 1 week's time, my lord. My lord, we as per my lord's last order, we have served upon the state, my lord. But my lord, kindly, my lord, it's this matter, Mr. Shrijit Chakraborty, but he's in legs before courtroom number 1.
My lord, I am raising strong objection because it relates to, my lord, the life of a student. He is going to appear a final examination for the month, this month itself. Unless, my lord, everything would not be regularized, he would not be permitted to resume his entirety in the normalcy. So there is a difficulty, my lord. On previous occasion, my learned friend also took time. I have concluded the argument and the state also submitted the report.
No, Lordship, we have not submitted.
No, on the previous occasion.
Lordship, there is a further direction to file the report, Lordship.
So I have been informed that, my lord, during the course of investigation, nothing was found against him. He is also a victim of the circumstances.
Okay. But I'm not briefed in this matter. Let my learned senior friend make all this submission.
No, I have completed my submission, my lord. If, my lord, is time, in that event, kindly keep online order, my lord, saying that, my lord, the pendency of the litigation will not stand in the way.
Kindly do not make such observation, my lord. I am not in the matter, my lord. I should not make any. I'm just humbly praying for.
On previous occasion was a short time, my lord.
I'm just
We do
humbly
not
praying
object.
for a time, my lord, on the ground and of Mr. Chakraborty, as he is in legs for courtroom number 1, my lord. Kindly do not make such observations, my lord.
And the difficulty is this, my lord,
Kindly
this
keep it
court
by the
would not
next
be
week,
the
my
so
lord.
far if the business of this court is concerned, my lord. Even if, my lord, your lordship would not be in a position to take up the matter tomorrow or day after, it depends upon the business of the court. I cannot insist to your lordship, my lord. So naturally, when the next day will come and when the matter will be taken up,
Generally,
you
my
are
lord
seeking
takes
for the
this
same.
matter on Wednesday. My lord,
Might be, but any urgent matter will
matters on
come.
Wednesdays, my lord.
Suppose any urgent matter will come. In that
Yeah,
event, that will
only,
be,
my lord, I am praying before
precedent
lordship
should be
to-
given.
এটাকে অন্য একটা ডেটে রাখুন। When is the exams?
Exam is, my lord, in this month itself. কবে?
College final in this month.
ডেটটা কবে বলতে পারবেন?
8th August.
8th August.
If it's next week, my lord,
8th August.
নেক্সট উইকে ওই
matter can be heard out before 8th of August.
শেষ হবে না, তখন পৌঁছতে পারবো না। আমি টপে কবে দিতে পারবো দেখো, একদম ফার্স্ট আইটেমটা থাকবে অ্যাসাইনটা দিন নিয়ে নেবো। 8th August.
8th August is the exam date, my lord, and the form fill up and everything would be done on the 15th July.
15th.
15th is today.
Then
My lord, I don't think there is any impediment.
No.
That's
If
not
unless
true.
the approval would not be accorded, he would not be permitted to appear.
Then
Kindly keep it next week, my lord. Any day subject.
how we will get the permission now?
My lord, as far as what I have understood from going through the record, my lord, that
You are-
he's already taking already
No,
taking
no,
classes.
1 year back, 1 year back.
He's already taking classes, my lord.
We have the notification with you that 15th is the last date.
Notification দিতে পারবেন 15th is the last day.
And it's a submission from the bar, my lord.
Well, kindly. First year exam for তো যেটা এটা কনফার্ম This is the last date of the form fill up, Milord, and he is appearing for the university.
So you can show no. Let him show the notification.
Notification টা দেখান
At present, I don't have, but I sure because I have a subject.
No, he has handed over the same to the other code also.
First year.
Huh.
God. Online থাকলো জজ সাহেবকে দেখাবো
My lord, even if in that case also, my lord, if my lord hears it next week also, my lord can direct the authorities to regularize his form fill up, my lord. My lord has that power, my lord. All I'm saying that 8th August is the date of examination. Before that, my lord can hear and conclude this matter, my lord.
So college has nothing to do with your filling up of form?
Yes, my lord. It's with the university, and my lord has the power to direct that.
Approval would not be accorded. In that event, everything would not be formalized.
He may be allowed to.
First profession annual data.
He may be allowed to submit the form subject to result of the writ petition, whatever order is passed.
My lord can hear finally on the next week itself.
Mr. Mondol. Yes.
Kindly, Lordship, because this is a
Report filed by the state is taken on record. Mr. Mondol, learned advocate, appearing for the petitioner seeks accommodation on behalf of Mr. Srijeev Chakraborty. No, appearing for respond number 8, no?
My lord, who is the recalling applicant, my lord?
Yes, yes. Respond number 8. Applicant respond number 8. Mr. Shubhobroto Datto, learned advocate for the petitioner.
Theoretical exam
submits that
September 3rd থেকে
today is the last date for filling up of form. For which semester this is?
It will be my first professional MBBS examination.
First professional MBBS examination. Seeks that petitioner be allowed to submit his form for appearing in the aforesaid examination. Liberty is granted to the petitioner to submit such application for semester 1 of a professional examination, which will be subject to result of this writ petition. Yes.
This is the, I suppose this is the recalling application. My lord is hearing the recalling application.
Yes.
My lord, I have been informed that there is a procedure that unless the specific direction would not be given upon the university,
Registering his name, he will not be allowed to.
He is appearing for the university.
No, I'm not.
Kindly do not make all this observation at this moment. Well, there is ample of time.
Observe this subject to final result of the
Yes,
ample of
let him submit the application subject to result of the writ petition. The writ petition come up bolo date যেদিন নিতে পারবো 8th August is the date for examination. Prior to 8th August and date board.
8th August এর আগে আছে exam.
কবে আছে?
আগে আমি তো next week.
Theoretical exam start from September.
না ওটা ঠিক আছে।
না 22nd এ নেব 22nd ওইটা আছে আরেকটা যেটা ছিল ওটার পরে এটা একটা করে নেওয়ার পরে সেকেন্ড আইটেম রাখো এটা হ্যাঁ kept to the record.
When my lord is keeping the matter, my lord?
Next week.
Next week.
Next week, second item this will be.
Any particular date?
Next week.
Next week, 22nd July.
Next Budhbar.
My lord. Only apprehension is this our Milord not to attend.
That is not in any of our hands.
Now he has come. To make your replies, it is 8th August is the date. So I have allowed him to submit the application subject to the result of this particular application recalling.
Form fill up টা করবে form fill up.
Form fill up examination 8
Examination form fill up.
Let him file an application for that.
Oh,
he has not prayed for that. Lord, it's my
I
recalling
have given.
application. He has not prayed
No,
for
no,
that.
let him submit the application. We'll decide on the recall
Lord,
application.
the writ petition is disposed of. In my application, Lord, let him come back with that the form fill up is going on. He has not filed any
He will
application.
file opposition. Thereafter, hearing would be there. After
So
2 years,
obviously,
that would
Lord,
be
he has to
adjudicated.
approach the
Then I
court.
will record that it has been informed by the learned advocate for
Lord, the
such and
document
such.
is not before my Lord. Let him
That
file an
15th
application.
July is the
Lord, keep
last
it on
date.
Monday.
No, no.
They should not be prejudiced anyway.
Today is the last day.
Lord, today is the last day. He waited for today, till today. He waited till today, knowing that today is the last
Because
day.
the matter has been fixed today.
It was appearing on the last week also. He waited till
No, no,
today.
what is the difficulty? If he submits the application, what is the difficulty? That will be subject to the result of this
Lord,
application.
let him file, come up with an application.
He will file an opposition.
But I
thereafter.
don't like this running commentary. I am addressing your lordships. I am not here to fight with him.
No, I am also.
Request, then please allow me to say. You then say whatever you want. Lord, Lord, this way. This is a court, not his drawing room. He should understand this. This is a court.
Mr. Chakraborty, then show me that 15th is not the last date, 8th is the last date. I will recall that.
So they are not coming with anything. I have no knowledge.
I have been informed on instruction. I have
But
submitted.
I have no knowledge.
University is
Lord,
also there.
only one thing, Lord. I am not against anybody. He filed a writ petition. He got extended the time. He got admitted in a wrongful way. That's our claim. Now, my Lord, he is there.
Hear out the matter, my Lord. In that event, the issue would be resolved. Yes.
Very good. I'll address your lordship and close the matter. Very good. Petition to daw na aanu na se 5 নম্বর কোটের কাউকে ধরে কাম লিস্টটাই নেই এখানে আইপ্যাড আনতে বলো কি করছিস Lord, my case, just to keep your lordship engaged for a minute, my case before your lordship was, Lord, that the admission itself has been procured by practicing fraud. If an admission is procured by practicing fraud, fraud unravels everything, then whether we have allowed him or we have not allowed him, we have shown benevolence, we have complied with court's order, that does not mean that it will give him a premium. Question was whether he could have got himself admitted on day one, whether he was entitled or not. That's the only issue that we have raised in the recalling application. Lord, Mr. Dutt.
May I interject?
Lord, please don't allow him to interject.
Only technicalities. He entirely submitted everything. I have given the reply. Only this is the turn to give the reply submission on my submission on the legal issues. Because I will not be, Lord, once again I will not reiterate and I will not be, Lord, waste your lordship's time by saying all the factual aspects once again.
Lord, I hope he will now rest for some time. So, Lord, today your lordship is considering an application for recalling of an order passed by Justice Basu, allowing him admission. That's the whole and soul of the story. Now, to buttress my submission that your lordship should recall the order, I have to show that the order was obtained by fraud. That's the only thing I need to show you before your lordships. Today a submission has been made. Please give me my iPad. Okay. Please give me my iPad. Today a submission has been made that today is the last date of form fill up. I have no idea about it. I would have understood that an application of student, if he is so concerned, he would have come with an application before the court in session of the matter, seeking some relief, not from the bar. I don't disbelieve Mr. Dotto. He must be acting on some instructions. But this particular litigant has a history of making false statement before the court. But since he is there he was given provisional admission, definitely as long as the matter is pending, he will definitely go and appear in the examination because your lordship has not cancelled this provisional admission. That much understanding I have. But my only concern is that since it was the duty of the writ petitioner to at least come and show your lordship something, that today is the last date. Or why was he waiting till the last date? He could have mentioned the matter. He could have come before your lordships. That's the only concern I am expressing. Now, since your lordship has taken up the matter, kindly take up my can one. Kindly take up my Can 1. I am not reiterating on the facts, just to answer his questions on law. But I have to show your lordships, my lord, or for your lordships kind recollection, I'll just show it to your lordships. A submission was made that we have not forwarded his name. How will he fill up the form if we have not forwarded? We have forwarded long time back, immediately after giving in the provisional admission. My lord may recollect on the last day he said, my name has not been forwarded. I am carrying that document, it was forwarded long time back. Misleading statements are being made before the court repeatedly. Mr. Dotto on the last occasion, if my lord recollects that he said my name has not been forwarded, it will be closed forever. I have taken instruction, it was forwarded. We have done our part. Lord, we could have refused him
Can you
admission.
show from my submission that I have stated that the Lord that has not been forwarded?
Lord, the other
From
lawyers
what
are,
which has
he
been
may lie,
repeated by your lordship.
he may lie, the other lawyers are here. He may Lord disown the submission, but that's not
No,
the
why
point.
he,
Yes.
what he is saying, Lord?
No, he is disputing it. He said that.
Misleading statement.
Yes, kindly take
I am belied.
Kindly take the application. Kindly take the application. Lord, kindly only for a moment take me, Lord, Can 1. Kindly see my prayers in Can 1 once. Lord, kindly take my prayers in the Can 1 once.
Can 1 to go to the supplementary one.
But till such time, if your lordship has the writ petition, just 2 paragraphs from the writ petition I need to show. Supplementary affidavit to the expert order. জিজ্ঞাসা করো মক্কেল কাছে ফর্ম ফিল আপের ডেট কি শেষ করা উচিত ছিল যদি মামলা করার সময় বাইরে থাকবে আমার কাছে কেউ আসে না ভাই I don't like
it. You can. Why the can write supplementary affidavit?
মামলা করে শেষ করে দাও যা হবে হবে বাড়ি কি হবে মামলার সঙ্গে কি আছে আমাদের মামলা আমাদের কি সম্পর্ক মামলা চলছে রিট পিটিশন
Yes, can. Which page?
Look, page 13 of the can application.
Yes.
But kindly, we have prayed for recalling of 12th November 2025 order passed by Justice Basu. Let us kindly got that. That's the prayer. Now, we have filed a supplementary affidavit. After some point of time, we'll take your lordship a little later. Kindly take the 12th November order once. 12th November order at page 16 of the application. My lords, kindly got that?
Yes.
The petitioner, being a successful candidate of NEET UG 2025, had participated in the counseling conducted by the Medical Counseling Committee. Respondent number 3 herein for admission in the medical course in West Bengal. In the third round of counseling, the petitioner was allotted Sri Ramakrishna Institute of Medical Science, Sonoka Hospital, Durgapur. Respondent number 8 herein under unreserved category against the state quota, but he was denied admission purportedly for his failure to furnish bank guarantee. That was his case before the learned single judge. Mr. Swanso, learned counsel advocate appearing for the petitioner, submits that petitioner to get the admission in the allotted college is obliged to furnish a bond, not a bank guarantee. Mr. Swanso, learned counsel for the respondent number 8, submits that petitioner is required to submit a bond to be executed before the first class magistrate, but he did not do so. Mr. Mukherjee produces a copy of the bond executed by the petitioner before first class magistrate Alipur, District 24 Pargana South, and submits that this bond would be submitted before the college. Mr. Chakraborty, on verification and instruction, submits that the said bond would suffice the purpose. The petitioner is directed to approach the respondent number 3 and 8 with said original bond to complete the admission process. The respondent number 8, upon production of the said original bond and upon compliance with the other formalities, shall admit the petitioner, and thereafter the respondent number 3 shall regularize the said admission. The respondent number 3 for the admission of the petitioner is directed to block the seat allotted to him. That was the direction. The case made out in the writ petition was that his father went there to Durgapur to got the draft done on 6th of that particular month. He went there and got the college insisted that you have to give a bank guarantee, although he had the bond, but college refused admission. That was the sum and substance of the case. And he produced the bond during the course of hearing. We got that bond. But I am not an expert. I sent it to my client by getting photocopy. They said it is all right. Later on, it was found on the next day that the entire bond is fake. Was, if I am not wrong, it was 8th of November. By 8th of November, if he's in, he's in. If he's out, he's out. I'll show you, Lordship, that particular document only from the writ petition. Why I say fraudulent? Because if he crosses 8, the order was passed on 12th. His case was, I had the bond affirmed on 6th. So I was within time, the college did not allow me. Later on, it was found that on 6th or on 8th, neither he had the bond nor he had the bank guarantee. So he was ineligible to be admitted on 8th of November. That is why this fraud was engineered. Whether he had got it done, through someone else, what the criminal or the investigation says, what the police says. But the fact remains, writ petition থেকে পেজটা বার করো 8 November. From the writ petition case made out in the writ petition and from the document given to the court, he was not eligible to be admitted. Kindly side by side take this page, my lord, of the writ petition. Lord, page 49 of the writ petition. Page 48 is the document. The document says tentative revised schedule for counseling WBNET UG 25 state quota, private management quota, NRI quota, or seats in West Bengal. Kindly turn the page, Milord. Take serial number 8 once.
Yes.
The reporting and admission of allotted candidates to the allotted institute of all private medical college and the admission process will be in different government medical college in Kolkata. Related notices has been published in the website and for all private medical college at Dr. R. Ahmed Dental College with requisite original document, college requisite fee and bond. Once successfully re-verified, they can get admitted and in the allotted seat. Time on the right hand side, 6th November, 7th November, 8th November, 11 to 4 p.m. His case in paragraph 11 of the writ petition at page 8 is that on 6th November, petitioner through his father immediately approached the bank at Durgapur, got the draft done. Thereafter, petitioner immediately approached the college for reporting admission as per the provisional allotment letter. Along with medical to domicile certificate, to the utter shock and dismay of the petitioner, the respondent college arbitrarily, illegally refused to grant admission, insisting upon production of bank guarantee. Lord, kindly appreciate this. I am not against a student. I have a strength of 250 students. It is very minuscule for me as a college. I am not against him. I have to save the institution and the system. I cannot allow people like him. He may be the brilliant student, the best in the lot. He got a state quota seat. He has to be a brilliant student. He's a general candidate, not a schedule type. I'm not undermining, not a quota student, but he got a state quota seat. But on that particular day, he was not eligible to be admitted. He did not come. He came to court on 12th, saying that college has insisted bank guarantee. We said we have never insisted because as per my instructions, 30 students of the state quota have been admitted on bond. The MCC guideline allows me to take either bank guarantee or bond. If I have admitted 30 students on bond, why one on bank guarantee? He said that I had the bond with me. Just to come within the timeline, nothing else. It was never his case in the writ petition that he was carrying the bond, despite the bond we thrown it out the Institute of Bank Guarantee. He said, we have said you come at bank guarantee. But in court, he produced the bond. Now kindly appreciate, my lord, if this bond was found to be ingenuine on the date of passing the order, the court would not have passed the order. No court would pass the order. If I come to your lordships with a bond which your lordship apparently finds that it is illegal or ingenuine, your lordship would not pass the order. Court was misled to believe it will be true. I was misled to believe to be true. I sent it to the client. He was misled to believe it to be true. But how we came to know, just have a look at the bond once. He is coming back with several ideas. Now, this is the sum and substance of my case. If my lord feels that with this sort of a credential, your lordship will not recall the order, I'll rest my case. But on that day, he was not eligible. Kindly have a look at page 18, the bond that he produced. Not kindly come to page number 22 first. Page number 22.
22
of the application. I'm sorry. I'm so sorry, my lord. I'm so sorry. Because all the now my lord need not look into the writ petition. All these are in application and supplementary affidavit. My lord, this 2769, this is fake. The entire stamp, seal, sign of the magistrate is fake. The lawyer is dead. His seal, his stamp, his signature is fake. At page 22. The petitioner produced it at the time of hearing. We believed it to be true. We wrote to the magistrate. Kindly have a look at the magistrate's response at page 24. কুড়ি কত কুড়ি প্রথম অর্ডারটা কত ওহ এটা নয় তারপরে যেটা প্রথমবার বলবো অ্যাডমিশন দিও না দেখানোর আছে The magistrate's reply is at page 25. The court's reply with reference to the above, I am to inform you, affidavit bearing number was not issued from this office. We moved to your lordship's court by filing this CAN application. 17th of November, Justice Basu passed an order. My lord will have that in your lordship's file. Not on 17th November, Justice Basu, after hearing me, and Lord, after holding,
Yes.
My lord, kindly got that. My lord need not trouble your lordship's not with the entire thing. Kindly take the first page. This is an application by so-and-so praying for recalling of the order. Petitioner was successful in NET 25 in the third round counseling. He was allotted. Petitioner in the connected writ petition has alleged that college is illegally insisting furnishing bank guarantee as a condition for admission. Writ petition was disposed of. The order is quoted. Mr. So-and-so submits that the college authority on production of the original bond had detected some interpolations in it, and as such it was not accepted. However, on the basis of the available photocopy, college authority took steps in ascertain to veracity of the said bond, and in furtherance thereof, learned advocate for the college, Ms. So-and-so, by a letter dated so-and-so, had prayed before the learned chief judicial magistrate, before whom the oath was allegedly administered on 6th of November in relation to execution of the said bond. In reply to the said letter, head clerk has said, Mr. Chakraborty further submits that the petitioner has practiced fraud upon the court by producing forged document. As such, DIG CID is be directed to investigate. Mr. Chatterjee, learned senior advocate for the petitioner, submits that the petitioner is not shying away from an investigation, but the allegation is yet to be proved. At this stage, the college should not put the career of the bright student, like the petitioner, at stake. Heard the learned counsel, in view of the letter bearing number so-and-so, Office of the Judicial Magistrate, being first class magistrate so-and-so, a prima facie doubt regarding the genuinity of the bond executive petition has been created. Therefore, the direction of the court upon the West Bengal Medical Counseling Committee and the college to complete the admission process of the petitioner upon production of the said bond shall remain stayed until further order. Then the respondent number 8 is directed to lodge a formal complaint. Original bond produced by Mr. Chatterjee to be handed over to Mr. Chakraborty for keeping the same in custody. But after this, we lodged an FIR and we came back to your Lordship's court. Justice Basu on 20th of November 2025 not allowed the petitioner. Lord, again like today, the last day, it was moved. Kindly take the 20th November order once. Kindly come to the last page, page 3. Heard the learned counsel for the parties, peruse the materials on record. Today is the last date of admission. The bond produced by the petitioner to get admission prima facie appears to be forged document. However, the involvement of the petitioner in the act of forgery is yet to be established. Therefore, it will be inadequate to deny his admission at this stage. Petitioner respondent number 3 and 8 are directed to complete the provisional admission of the petitioner subject to production of a fresh bond within the scheduled time today and subject to prima facie satisfaction of the respondent number 8 regarding the veracity and format of the said bond. Admission of the petitioner is subject to final outcome of the pending criminal proceeding. In the event the petitioner is found guilty in the said criminal case, his candidature seat allotment shall be cancelled with immediate effect, and in such event, petitioner will be liable to compensate the college as per the bond. The petitioner, if fails to produce the bond today within the stipulated time, direction to block the seat allotted by the petitioner shall stand vacated, and the petitioner number 3 shall be at liberty to put the said seat in the next round of counseling. DIG CID is requested to investigate so and so. So, my lord, he was directed to produce a fresh bond, and we were allowed to check the veracity and format of the said bond. Now, that's the third paragraph of the order. Maharaj Kali got that?
Yes.
What are you doing? Lord, I have received an instruction that he is already registered with university. So registration we have completed, and I asked that is today the last day for registration of MBBS examination? The answer from my client is not even started. So let him produce it, my lord. Whatever order my lord passes today,
What
he
is
should
the
produce
instruction?
that. I have, from my client, I wanted to know whether the registration has been started. My client says it's not even started.
Oh.
Let him. I am proceeding with the writ petition. Let him produce that only for this, my lord. So after 20th, we will not preferred an appeal against the 20th November order before the division bench.
This
Lord,
you have shown earlier occasion.
Yes, I'm not, just for your lordship, I'm not showing it. I don't need to show it. Now, my lord, so after the division bench sent it back, now, my lord, after that, just take the supplementary affidavit once, only one page I'll show, then I'll not go to the legal issues. I'll take the supplementary affidavit once. ফর্ম ফিল আপ চালু হয়েছে কি জিজ্ঞেস করো ফর্ম ফিল আপ চালু হয়েছে দেখো সেটা ভুল হলে কারেক্ট করো ভুল ইনস্ট্রাকশন দিও না my lord
Yes.
kindly got the or my lord may take
Yes,
my
yes,
copy
yes.
I'll just show
I have
one
got-
page.
Yes. Yes.
Lord, 20th we have given him provisional admission. Lord, just to comply with the honorable court's order, although we challenged the order later on, we have given him admission. Take me lord page 11 once. Kindly see, my lord, the declaration that given by the petitioner. This is subject to verification of the submitted bond and its components as well as further direction from the Honorable Court at Calcutta in the above mentioned case. Lord, we have made out twofold case before your lordships. One is the element of fraud, and second, that even the bond which was produced before us, that was an incomplete bond that did not bear the signature of two of the sureties. Justice Basu, by 20th November's order, allowed us to verify the bond. Since he has failed to produce a proper bond, his admission should be cancelled. Now, my lord, my first round of challenge remains whether he has been admitted or not, because fraud unravels everything. On 8th of November, he was not eligible to be admitted. Unless and until he had shown the 6th November fake bond, he would not have got that admission. He took a chance, he produced that fake bond, which has been proven to be fake. Lord, kindly for a moment, kindly consider, let us take a situation that he has not been admitted as yet. I am for the college, today he is coming and seeking admission. It would be my submission before my lord that as on date he is ineligible, he has crossed the chance, missed the bus. He cannot now come on the strength of a backdated bond and get the admission. Had it been made known to the court that the bond was fake, court would not have passed the order. So his right accrues from the 12th November order, which has been produced on the basis of a fake document. Whether he is the accused, he is not the accused, he is responsible, he is not responsible, he is a victim, but the order was obtained by paying fraud on court, and he is the beneficiary of that. So he was not eligible on 12th of November or on 8th of November. He could not have secured the admission. That's my first line of argument in the recalling application. With greatest of respect, I have not found any submissions from Mr. Dotto saying that no fraud doesn't unravel everything, or 8th of November he was eligible. He countered the other portion of the submission that the affidavit, the bond may not have been signed by two, it need not required to be signed by two. If I have understood his case correctly, he went into Transfer of Property Act, mortgage, undertaking. But my lord, what about the first step? My lord, my learned friends appearing for the university and my lord, the NMC would apprise your lordship, my lord, that the Supreme Court is very categoric about the extension of dates. The ASA judgment is very clear that you cannot extend the date. High courts cannot extend the date. What we do every year, this year also we did it. The MCC cannot complete the admission. The seats remain vacant. This year for the association, I moved the SLP before the Supreme Court for the Association of Medical Colleges. We got the date extended. Only Supreme Court extends it. So by virtue of this fraud played on your lordships actually extended the date of admission, which ended on 8th of November. My lord on 12th of November directed me to admit him. So that's the element of fraud. And why I say so? His pleading in para 10 of the writ petition says his father was there on 6th of November, Durgapur, to get the demand draft from the State Bank of India, Durgapur branch. And the affidavit bears his father's signature, which the forged affidavit, which is dated 6th November. So his father could not have been there at two places at the same time. So he knew it is a fraud document. He knew his father was not there. And why this was done, my lord? This was done because he got the admission in counseling round 3. As per the MCC guideline, a student candidate who got admission in round 3 and who remains unreported, he cannot participate in the further round of counseling. Page 35 of the writ petition. I will not trouble your lordships. The candidate who remain not reported in the round 3 after allotment are not allowed any further in the counseling process, and they are out of the counseling process. So he knew that he missed the bus on 8th. He knew it. He got that document from somebody. I accept that he did not do it. He did not himself put the stamp. He did not himself made the magistrate sign. But he approached High Court on 11th of November, got the order on 12th of November, when he was completely ineligible to participate in the further round. So he had no option but to produce a fake document. And he has exactly done that. So the first order, if it goes, everything else will go. Whatever happened thereafter will automatically go. Provisional, not provisional, admission, no admission, everything will go. I did not hear any answer on this, that no, he was eligible on it. ফর্ম ফিল আপটা কবে দেখো না তুমি, ছেড়ে দাও, বাদ দাও ওটা, লিভ দ্যাট, যা বলেছে বলেছে, ডাজন্ট ম্যাটার, ইউ আর ডুইং দ্য ম্যাটার, উইল ফিনিশ ইট। Lord, your lordships are always kind to the students. Always, your lordships are always kind to the students. But one should not be allowed to take advantage of that kindness. My lord, if we see the chronology of the events, it clearly indicates a particular motive. Lord, whether I am not going on the aspect of form properly signed, not properly signed, mortgage, transfer of property, but his statements in the writ petition and his action. Paragraph 11, just have a look at it. My lord will admonish me a little later. Kindly look at para 11 once only. And this was affirmed. Please thambe. He says, Lord, kindly come to the affidavit. Paragraph 11 has been affirmed as derived from the records, knowledge derived from the records. What is the record? In support of para 11, he annexed, my lord, annexed P11, which is the bank draft. Just to show, P11 is at page 55. Just to show that the bank draft was obtained on 6th of November. His pleading is on 6th of November. The petitioner, through his father, immediately approached the State Bank of India, Durgapur branch, and prepared a demand draft dated 6th November of rupees so and so in favor of the respondent number 8 college. But it is appearing from the record. Then if his father was in Durgapur, then how can this bond, which is fake, carries his father's signature? So his father knowingly signed on this, and this was produced in court. This signature may not be of his, but I'm just trying to emphasize on your lordship's note that it was a well-engineered plan, because he missed the bus. His case that his father was in Durgapur on 6th, but before magistrate Alipur, his father has signed. How could you be there at two places at the same time? Then one is a lie, one is a false statement. The one made in the writ petition cannot be, because the bank draft is a genuine document. So the one, this is a forged document. So you obtain the first order on the basis of this forged document. But kindly, for the present, let us not go into the other aspect of the matter. Bond, one father signed, mother did not sign. He says mother was in Baharampur, mother could not come. I am not going to that aspect. But the initiation, if the genesis is wrong, the building has to collapse. Lord, I'll just rely, in reply, I think I can rely on a judgment, my lord. On the question of fraud, if my lord takes note of it, 2-3 paragraphs, Mr. Dotto is very well aware of this. Lord, 2025, Supreme Court, SCC Online, SC 1501. Fraud unravels everything. This is on fraud unravels everything. My lord, I'm sorry.
Order dated 20th November.
Yes.
The court says that the admission of the petition is subject to final outcome of the criminal proceeding.
My lord.
Is it so that the court intended for the investigation to complete or the trial to complete?
But I believe,
because he says that charge sheet has not been filed against the accused. But there is a provision in Criminal Procedure Code. If the court finds that there is allegation, it can add him as an accused.
Court himself under
So
311.
if it says criminal proceeding, Mr. Dotto, it will be interpreted as a completion of the investigation, and it also continues that in the event the petitioner is found guilty. Investigating authority cannot find a person to be guilty. It is after the conclusion of trial that a court finds him guilty. So
if there are overwhelming
why
material,
this matter was mentioned before this court for taking up for expeditiously until and unless there is a direction that you wait for your time, because the trial will begin now. Charge sheet has been submitted. You both of us clarify this aspect subject to conclusion of the criminal proceedings. It does not say criminal investigation.
Proceeding would
as of
include
now.
Let him.
No. But I would say that these were, apart from this, if the first order goes, all this goes. If
no,
the court has
admission was subject to conclusion of the criminal proceedings. As of now, 20th November 2025 order is there, on the basis of which he has taken an admission. Now, whether without conclusion, the court can very well proceed with the writ petition and give a direction whatsoever, whether if the admission was correct or incorrect, whether that finding can be given at this stage when his admission is subjected to findings by the court in a criminal proceedings.
Lord, proceedings would normally, it would not indicate, it indicates that under 311 the court would have power subject to, I may quote a wrong section, Lord, I don't know, 313 perhaps, 313. The court can ask questions, Lord, and can add him also if there is overwhelming material. I'm not sure. But Lord, the trial has not started. Now, so the admission of the petitioner is subject to the final outcome of the criminal proceeding. In the event petitioner is found guilty, the candidature seat allotment shall be cancelled with immediate effect. In such event, petitioner will be liable to compensate the college. Now, what had been meant by the proceeding?
Mr. Dotto?
But I would have to consider this. I would have to consider this because
this order is conditioned.
Absolutely. But this order is an offshoot of 12th November order.
Correct.
Had the 12th November order not been passed, then by 12th November, court directed me to take
a correct approach to decide the issue prior to a criminal court finding him guilty or not guilty, whatever.
And I have asked my client to file the Naraji against this charge sheet, my lord. I have not been put on notice. I have already asked, my lord.
Mr. Dotto, what is your submission?
My lord, so far is the, my lord, my learned friend's point is concerned, I will, my lord, reply later on. Prior to that, my lord, what was fallen from your lordship, my lord, the word proceeding which has been mentioned, the purpose is this, my lord, that the issue was the student, the petitioner before your lordship was not allowed to take admission. My learned friend has stated fraud in so many times, and one judgment has been placed that the fraud unravels everything. My learned friend is also aware of the fact that when somebody say fraud, the factum of fraud are required to be mentioned, and everything, tits and bits are required to be mentioned in the pleading. In paragraph 6, which is the
no, we are going to other place. No.
So I am
trying to clarify this situation. The court has used the word proceeding.
My lord, since my lord, the court, without my lord submitting in a different way, the terminology which has been mentioned, the proceeding, only mean to investigation. Why I am saying so, my lord? Because your lordship can take judicial notice of the fact none of the criminal proceeding or the, my lord, the trial would not be commenced very shortly. The tenure of the program is 5 years. That would be 5 years. That cannot be prolonged. So if that interpretation would be given, in that event, it would be infructuous. If the interpretation is required to be given. Proceeding includes completion of trial. In that event, when the trial would be commenced, prior to that, my lord, entire my lord program would be completed.
For seeking a final order of admission which is subjected to the criminal liability.
No, criminal liability means here, my lord, a thorough investigation has been conducted. During the course of the investigation, my lord, it is not that a final report in the form of false or true has been submitted. A charge sheet has been submitted. So since the charge sheet has been submitted, the wrongdoer has been fixed, their liability has been fixed, adequate evidence has been collected. It is not that the fraud was not there or something was not there. So that is there. But the victim has been the writ petitioner before your lordship. So where, my lord, it appears from the evidence itself. Because since, my lord, the charge sheet has already been submitted, the procedure your lordship knows better than me. Immediately. Since, my lord, charge sheet has been submitted, the charge sheet would be accepted by the, my lord, the learned jurisdictional magistrate. So that I think, my lord, after filing that charge sheet has been submitted before the appropriate jurisdictional authority, judicial authority. So that has been accepted. And it appears from the charge sheet itself that nowhere there is no single evidence. There is no single evidence against him, and he has been portrayed as a victim of the circumstances. So even if, my lord, if your lordship can take judicial notice of the fact that unless there would not be any evidence, even the court, my lord, would not be in a position to induct someone as an accused person. So for which, suppose in few cases, suppose police, while filing charge sheet, there are evidence. But despite their evidence, somebody has been discharged. In that event, or any other persons whose complicity is there, it appearing from the, my lord, the evidence, in that event, my lord, the learned court can do that. But here, my lord, if that interpretation would be given, it would be completely meaningless. It would be completely meaningless.
So that's why I'm asking you, my lord, that getting a final order in a writ petition saying that since prima facie charge sheet is a prima facie document, it's not. So prima facie there is no allegation. You say that none of the witnesses say so. But when it goes into the trial, and there is also provision that where you can pray for additional evidence. Court for clarification, the trial court can call for evidence from
my lord.
Other.
My lord.
And final order is passed, you take admission. Without conditioning the order which was there, and ultimately upon trial, the person is found guilty. What happens to that admission?
That will go.
How it will go? If we do not take into consideration the condition that is imposed in your admission, and a final relief is granted to your client, and ultimately in criminal proceedings after trial, it is found that no, you are guilty, then what happens to that admission? Because both are court's order. One court finds it was conditioned, so admission was conditioned. So never the word has been used as investigation. It follows with the third line. It says that in the event the petitioner is found guilty in the criminal case, what happens to that? That you can clarify.
So, my lord, in that event, I have to go through once again. But this aspect has not been, my lord, has not been considered by us. And while I have argued also. So, my lord, this aspect which has been pointed out to your lordship,
Now,
that has
when
opened up a new
I
vista.
was going through the
Lord,
order, if there is a condition, the court could have used the word once proceeding and another is a case. It never says that you initiate a criminal case and upon completion of the investigation, if he is found guilty, he is out of the arena. If it is not
But
found,
that has not been mentioned trial. It has been mentioned if he hold guilty.
But the investigating agency cannot hold a person guilty. It can file the charge sheet before the court to find out what will be the fate of that accused person.
For the court to find someone guilty.
Because
So,
I tell you,
kindly,
this is out of this. There is a charge sheet against accused. He is coming to the court. After trial, he is acquitted.
Yes.
My lord.
So can one say that charge sheet has been filed, so he is guilty of that offense? You cannot say so, because there is a process of trial. So if it is completion of investigation, it's something else. If it is completion of proceedings and completion of the case, then we have to wait for the subject of the trial.
My lord, in that event, if that would be the possible interpretation, in that event, my lord, the prejudice which will be occasioned. Suppose today, my lord, there is no prima facie evidence also. There is no single prima facie evidence against the writ petitioner, or my lord, accusing the allegation which has been leveled against him. Suppose, my lord, if that interpretation will be given, because sometimes, my lord, in few cases, sometimes writes writ petition, sometimes writes writ proceeding. So it is the my lord, the terminology which is normally being used in the different aspects.
Just
in
five words in that order.
perspective, my lord.
5 words in that order. Final outcome. 1.
My lord, he is not. It is
Criminal
not
proceeding.
Case. It is from the my lord,
Found guilty.
fallen from your lordship, my lord. I am giving the reply to your lordship.
Obviously.
Whenever he find time, my lord, he can add. There is no difficulty. So I am trying to say, my lord, the purpose or endeavor after filing the writ petition is this, so that a chance should be given to a student so that he can take admission. But a situation has come up where, my lord, certain allegations are there that the document is not the correct document, and to ascertain the fact, an investigation has been directed by this honorable court. And what is the outcome after completion of the investigation? As on today, he is not an accused. Since as on today he is not an accused, whether, my lord, so what has fallen from your lordship, that is correct. Unless completion of the trial, nobody cannot hold that he is not a guilty. At the same time, as on today, he is not an accused. So a person who is not an accused, he has to bear the ordeal of trial till such time, and he has to face the ignominy of entire period of the 5 years for the completion of his program. Even then, my lord, it is uncertain whether the trial would be completed or not. Okay. So, my lord, if that interpretation should be given, so I think that, my lord, it would not be reasonable for the student, reasonable for us to, my lord, to conceive of a situation where he will face such ignominy, where, my lord, he is not at fault. So since, my lord, it was fallen from your lordships, once again I am taking time so that I can, my lord, enlighten to your lordships, my lord, the provisions of law, my lord, and the interpretation so far as the proceeding word is concerned.
Lord, on the aspect of today's form fill up, check, Lord, his statements. Kindly have a look.
No, my lord, that is neither here nor
there. No, Lord, that was the issue for which he insisted the court to take up. That was the issue. So before we say something to court,
no,
we
today
must verify.
The matter was fixed.
Kindly see, Lord.
No order was passed.
He said that today is the last date of submission of form.
On instruction,
3rd September.
I have submitted.
3rd September is the date of examination.
Also told me.
3rd September.
3rd September the exam starts.
And the date of the filling forms.
Kindly take the next page. Verification of statistical data of students. 12th August, uploading attendance percentage. 14th August, 14th August to submission of signed original IA tabulation sheet. 21st August, online enrollment students. 21st to 26th August, admit card downloading.
My lord,
who informed
university, my lord? The university.
Downloading.
Kindly see that there is no my lord, the column for filing.
Lord, I have no role in preparing the form, my lord. I cannot say why it is not there. But the date of downloading the admit card is 1st September. Downloading attendance sheet 1st September. Submission was made that today is the last date of filling of form.
Coming weekend.
তুই বলেছিস
2 সপ্তাহ পরে আবার রাখো for further hearing.
ইউনিভার্সিটিতে এটাই বলবে, ওরা তো চিরকাল সাপোর্টই করে।
But Mr. Trijib Chakraborty, learned advocate for the applicant, response number 8. You have concluded.
Not only on the proceeding, I'll give a judgment to your lordship. On the proceeding, on the aspect of proceeding, nothing else. Your lordship wanted me to answer that only on that. And this judgment, may I mark the paragraphs on your lordship's copy?
It is.
আমাকে একটু দিন সরোজ দা, আমি প্যারাগ্রাফ গুলো মার্ক করে দেবো। I'll just write the relevant paragraph. পরিষ্কার হাতের লেগে প্যারাগ্রাফ গুলো মার্ক করে
এই
দেবো।
সাইটেশনটা একবার বলতো।
He concludes his reply.
25 SCC 1501, ঠিক আছে।
Is this matter on the query by this court, please this matter after 2 weeks. 28 তারিখে গেলে হবে? When is the exam commencing?
Lord,
3rd of August.
3rd September.
as per this 3rd September. University
As per the
Full against 29th.
third profession.
29th.
Milord, 28th I would not be available for my personal difficulty, Milord. Any day after 1st of August, Milord.
First
Any
of
day, any day convenient.
28th কবে? 20 জুলাই বলছিলেন যে স্যার?
5th then. 5th.
5th August.
I suppose you have nothing to submit.
My lord, I am for the National Medical Commission.
Okay.
My lord, I want to rely on judgment, my lord, of the Honorable Supreme Court regarding maintainability of the miscellaneous application in the disposed of writ petition. Nothing more.
Oof, manage করে নিয়েছি। বাদে এসে এসব উফ, ব্যাস। লিখে না,
My lord, kindly
রেফারেন্সটা বল ভাই।
বলছি
2024
SSC online SC 36777. My lord, kindly read only para 15, 14 and 15.
ফ্রড হয়েছে, সেখানে বলছে নাকি অ্যাপ্লিকেশন করা যাবে না। কোর্টের নিজের অর্থে সুপ্রিম কোর্ট has several times recalled orders.
Counsel and advocate for. You are for
National Medical Commission.
National Medical Council.
Commission.
Submit that such miscellaneous application is not maintainable in the present writ petition.
কোর্ট অলরেডি এন্টারটেইন করে বসে আছে, অ্যাপ্লিকেশন অর্ডার দিয়ে।
Your respondent number?
My lord, I am respondent number. My lord, names 9 probably, my lord. Just
National Council for
National Medical Commission, my lord, respondent number 7.
7 supporting the writ petition.
Reports furnished by the
Seven
state
at the-
respondent is taken on record over the din. 5th August. Next.
Lord, just for your lordship's Lord information, on the day when the students got admitted, Lord, he was also out of time. He reached out of time, but since there was an order,
His
we allowed.
intention is to prejudice the court in any manner which is not in the record. He is saying something, Milord, that on that day, because neither I nor my learned friend was
Sir,
there.
it is on
that
affidavit.
day.
I can show it. He has not gone through the papers. I'll show it from the
This is
affidavit.
neither
it
here
can show.
nor there. This
The
is
timing
the
is beyond time. The document shows. They still we allowed him. I don't Lord, normally submit or never try to submit, Lord, something which is not there on record. Or today say something, tomorrow backtrack. I don't do that. I have no personal feelings for the student. Nothing, Lord. And on the day one also, we only said that yes, we are allowing him to take admission. There's no objection from the college.
Generous, Milord.
No. It is the stand of the client. I don't need to be generous.
Come back on
I'm representing someone.
Which one? 68.
In this case, only your lordship direction was to serve a copy upon the learned government Peter. My lord, 13th May.
68
And my lord, I have served the said copy of the application.
My lord, it's already the compensation paid, everything been done. They did not take the
Unless
money.
this argument has already
State
been made
also has
earlier,
already
okay,
said
so
there is nothing
your
there in the
lordship
matter, my
directed-
lord. There were two proceeding LA 25 of 2012 and 13.
No.
Where the land of 0.215 was been acquired,
Okay, government Peter.
the amount was been paid. Thereafter,
My
in
lord, without
18,
any
19,
illegal
my lord,
evidence,
0.345 acres of land was acquired. That also compensation paid. They admitted in the writ petition, they got out in regard to LA 13, 2018-19, they got the amount. Now they raise out the question in 25, 2011, 12 and 13 acquisition. They did not take the money. Whereas the state on the last, that is on the occasion when the government was not changed, at that then they produced out a report that they said there was an advertisement in the newspaper to take the money in 2016, but they did not claim. Then they came out with one application that is there is a problem within the family, and that's the reason they never knew about it and they did not take. Now the thing lies out upon the competent authority and themselves. Now what the writ court is going to come out with this, my lord, writ court cannot decide who the compensation will be acquiring, but the amount was being paid. Now let them take that amount.
By your client.
Yes, my lord.
By your client.
Yes, that we paid out in 2016 itself, my lord. And that was paid to competent authority. And the competent authority made out an advertisement in the newspaper. What on the occasion when the hearing took place? They made an advertisement in the newspaper to collect the awards. They did not come forward. Now they in this proceeding they said we didn't knew about that proceeding in 12 and 13. So this time we came to know. Now there was a problem in them. They had a will. They had a some sort of problem. The family. That's the reason they could not collect.
He each and every time, I am appearing on behalf of the petitioner. Your lordship direction on each and every time comprising. Lastly, your lordship directed me to serve the copy of the landed government Peter. Because he is a competent authority. Your lordship can see the money. Your competent authority.
What is this?
I'll pick out. The awards were given. Even I gave it in the last hearing also. When the last hearing, my lord, this is a compensation. In regard to LA case, my lord, that was 25, my lord. 25. My lord, page number 1 is the amount. And the land is, my lord, number 2. Biruda, 25, 2012, 13. The amount was 11 lakh. This was net amount payable, my lord. Page number 2 says out, these are the check details, my lord.
So
thereafter, my lord, come to page number 3, my lord.
Dispute he is raising?
Yes, my lord.
He is raising what dispute?
No dispute is there, my lord. They say we did not claim the amount. So if they don't claim the amount from the competent authority, that is only kindly. It was their own statement.
The competent authority, my lord, he filed a report before your lordship. And report is that he is ready to disburse the compensation after verification of necessary documents. In this case, the petitioner, my lord, dictated will in favor of the grandsons and also some land division. And my lord, record our pair before your lordship to my lord disburse the money for the recorded owner. Recorded owner. It is our pair. He is not the my lord government. He is not the my lord special land acquisition officer. He is the railway authority. And we have come to know from the respondent affidavit that 0215 land was awarded and my lord did not receive any letter as well as the notice. Then my lord, I have filed your lordship directed me to file the my lord affidavit against the report as well as the my lord, I have filed here my lord synopsis of the case. Here my lord, first time my lord, his argument was that we did not agree to receive that, and I have thereafter he said I have already received the compensation, which is my lord beyond the record. There is no, we did not. Thereafter, my lord, your lordship has directed me to file the my lord opposition exception filed by the petitioner my lord, against the report. Your lordship has we have already my lord stated that my lord the area mentioning my lord paragraph 5 and paragraph 3A very vital. That one my lord Shambhunath Konar. Now this is the owner of the land in question executed will before the additional district sub-registrar on Ato, Sri Sanjeev Kumar, Chiranjeev Kumar, Prosenjit Kumar, previously Sahil Kumar.
Not filed any application before the authority, competent authority, that such and such person who has received the compensation is not entitled to receive that?
Well, we actually regarding
because there is an existing will.
Yes.
Will that be decided in the writ application?
No, my lord. But our application when
what is the provision under the Railways Act?
When the money is
what is the provision of acquisition in the Railways Act 2008?
Well, here is,
if you have any dispute with regard to the share, there is an authority.
There is no dispute, my lord.
Yes.
Your lordship only verbal argument. Your lordship can see the total my lord case of the petitioner. Your lordship actually your lordship direction, my lord, have complied the my lord all my lord. Even we again not issued the notice. Your lordship report to my lord, your lordship kindly see the report of the Special Land Acquisition Officer. Phase 2. 26 November 2024. Then my lord, the argument of the railway authority is my lord not proper, my lord. He says that no documentary evidence is that I received the said money.
State appeared on the last occasion.
My lord gave us the record, like the entire details of the check, what we paid out in the 2012 and 13. So thereafter in 1819, the second acquisition that took place, LA 13 also we gave out the entire amount. My lord, in the first page,
Specially assigned at a time then.
my lord, from 1 to 3 and 4 is in regard to LA case 2012 and 13, my lord. And my lord, in regard to
Specially assigned a aspect. Date বলো, নিয়ে নেবো।
কিছু নেই, আপনাদের ফ্যামিলি প্রবলেম নিয়ে এখানে কি আর বলি স্যার, আপনাদের
আগস্ট জুলাই যেখানে ফাঁকা থাকবে একটা দিন না, শুনিয়ে
আপনারা পয়সা 2016 থেকে নিচ্ছেন না জবরদস্তি। এর মধ্যে কি রেড কোড ডিসাইড করলেন? রেড কোড ডিসাইড
আপনি বলেছেন যে I have already
না আপনার বিলটা কি ডিসাইড করবে রেড কোড? কি আপনি চাইছেন?
হয়ে গেছে, we are entitled to
তো আপনি যান, আপনি ওইখানে
স্যার ওয়েট না 12 অগস্ট আগে এই যে শুরু হবে শেষ হবে না, বলছো উইন টুইন আছে না, অনেকক্ষণ চলবে। কামিং উইক বা আগস্টের এই 28 29
যা চলার আছে দিনই
12 তারিখে একদম টপে থাকবে। কি আছে 61 62 কি করেছেন ওটা মনে আছে কি আছে? কামিং উইকের চান্স নেই, দেখি কি হয়। ওটা 12 কে না একটা টাইম দিয়ে দাও,
মানে let an order be passed out.
আসুন।
মানে synopsis of the case, my lord, please.
Oh, keep that. We'll hear it out. On 12th August, on the joint prayer of the parties, place this matter on 12th August.
আপনার তো ফি প্রতিদিন ফি
কটা বাজে?
ফিস দরকার নেই স্যার,
3 PM.
আমি মামলাটাকে সালটাতে যাই,
3 PM.
ফিস দরকার নেই আমার। আমি রিলিজ করলে কেস করলেই তো ম্যাচ জিত করবো। অনলাইন ম্যাচ উইদাউট এনি ইনস্ট্রাকশন।
This revision and application is 20 of 2012, my
Lord, I am appealing on behalf of the opposite party. One, my lord, I am filing the affidavit in opposition.
No, my lord, the scenario in a nutshell, my lord, the wife was driven out of the matrimonial home
my lord, the 498 applications was filed, and along with, my lord, application under section 125 of the CRPC. Now, before the learned trial court, my lord, the wife lost. Before the learned appellate court, the wife lost. Now, thereafter, the matter came up to the Honorable High Court. The Honorable High Court, in my lord CRR, that is, my lord, is presently hearing, my lord, directed that the magistrate to consider certain issues and pass a reason order. Praying for modification, the husband, my lord, appeared. They challenged the same. The order was kept the same. No interference was made. They preferred an SLP before the Honorable Supreme Court. Supreme Court directed that all the matters are set aside and is returned back for fresh hearing on the issues, along with an, my lord, direction that on each month they would go on paying 10,000 rupees, and at a adamantium, my lord, 1 lakh. That 1 lakh was paid, but, my lord, 10,000 rupees has been lastly paid in March 2025. From March till today, my lord, now we are in July 2026. That amounts remains to be paid, and showing only the pendency of this application, my lord, they are not paying. Now the difficulty is, my lord, we cannot even approach the Supreme Court in a contempt application.
Where is the order?
Now the Honorable Supreme Court, my lord, kindly takes the supplementary affidavit filed on behalf of the petitioner. Page 37, my lord.
Your Lordship, I beg to appear for the opposite party number 1. Your Lordship,
He is summoned to the respondent in the first week of every month. Also, he has summoned 1 lakh to respond who responded.
Your Lordship, only one predicament that we are facing, since opposite party number 2 is the state. We have already filed our opposition over here, but without an official order, we are not being able to submit the state with regard to this opposition. And the second ground is, Your Lordship, I apologize to all the parties and to Your Lordship as well. There is some difficulty with regard to the instructions. Your Lordship, I will not stand in the way, but as a last measure, if Your Lordship may kindly grants us a week's accommodation, whether heaven fall, even if heaven falls, on the next week, we'll start the matter. Your Lordship, there is a difficulty with regard to the instructions that we are having. Your Lordship may kindly accommodate us for this one last chance.
Take instruction whether the order of the Honorable Supreme Court has been complied with or
Yes,
not.
my lord, kindly that. And what they happened, we said till March 2025.
Yes, absolutely.
This order dated. This is 4th October 2024.
Yes.
Is that every month, I suppose, from the month of November onwards, you have to make payment. That has not been made.
Your Lordship kindly grants us a week's accommodation, because
this has not been find out, because there is non-compliance with 1 lakh rupees was also supposed to be paid within a period of 4 weeks.
1 lakh is paid.
That some amount has been paid.
Okay.
And from
this has been
October-
complied, but the monthly amount is not being paid.
Yes, my lord, October 2024 till March 2025. They have paid.
Affidavit in opposition filed on behalf of opposite party number 1 husband is taken on record. Copy served upon learned advocate for the petitioner.
Yes. A copy.
Yes, my lord, opposition is with us.
Yes.
Petitioner.
Only the state is.
Advocate, Mr. So-and-so, learned advocate appearing for opposite party number 1 seeks liberty to serve the copy of the affidavit in opposition to the Office of Learned Public Prosecutor, High Court, Calcutta. Let such copy be served in the office of such and such. Learned advocate for opposite party number 1 seeks a short 1 week's accommodation. Mr. So-and-so, learned advocate appearing for the petitioner submits that the direction as issued by the Honorable Supreme Court for making payment of rupees 10,000 per month has not been complied with. Opposite party number, learned advocate for opposite party number 1 is directed to take proper instruction with regard to the submissions advanced on behalf of the petitioner. Release this matter next week. Coming week.
Thursday.
Thursday or Wednesday?
Wednesday, my lord, Wednesday. 22nd. Top of the list. My lord, let it remain its position, my lord.
এখানটা একটু কাপ হবে দাদা, কারণ সার্কিট গুলো আছে। Can it be just a week?
29th.
20. Your lordship, 22nd will be a bit difficult. Your lordship may please to keep it on 29th.
29th.
No, only request me if my friend is over, some payment could be made in the meantime. It is from the bar, my lord, if he could arrange for that. Certain payments, because my lord, there is admittedly alleging would be a
on 29th.
My lord, let it retain its position, my lord.
Yes, yes. একটু টপেই রেখো। ওই দিন আছে কিছু সিআরআর টপে?
29th
Grateful.
89.
এর খবর দাদা। আমি বলেছিলাম এ থেকে প্যানেল থেকে কাউকে একটু দেওয়ার জন্য। কোথায় সে? কল্লোল মন্ডলকে খবর দাও তো। পিপিকে 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 একটু খবর দাও তো। Ninety-one. 92. 93. 94.
95, 96, 97, 98, 99, 100, 101.
Lordship, I'm for the petitioner. Mr. Kishore Dotto is leading us in this particular matter.
Which one?
This is 101, Your Lordship.
My lord, 101, I appear for the opposite parties, my lord.
Yes. So, just a small accommodation that this matter be listed next week, Wednesday. It be fixed. Mr. Dotto will be leading us in this particular thing. If
What is the order impugned?
it will be on the page number 67, Your Lordship.
My lord, they are challenging, my lord, the dismissal of the complaint. My lord, it's a long pending criminal revisional application, my lord, which they have filed, my lord. The complaint was dismissed, my lord, based on the police report. My lord, I'll indicate, my lord, the police report, my lord. If, my lord, they wants to start, my lord, then they can start because they are criminal revisional application, my lord, which they are challenging with the impugned orders, my lord.
Okay. Which is the order impugned? Order.
It will be page number 67, Your Lordship.
$67.
Yes.
The certified copy.
Yes.
2467. Accommodation on the prayer of learned advocate, the petitioner. देखो hearing it. Hearing it did. Here are. Hmm? 29th July.
Very well.
Grateful, my lord.
One thing is that the investigating officer has filed its report with regard to 202 CRPC.
Yes, Your Lordship.
Yes, yes, my lord.
Yes.
Not only one indulgence, my lord. I
Yes.
have filed a short affidavit in opposition to the limited documents which I have seen on the file, my lord. Only I am praying, my lord, if my learned friend, my lord, could supply me a full set of, my lord, the CRR. So, my lord, in the interagnum, my lord, I could have filed, my lord, the full, after seeing, my lord, the documents, my lord, I could have filed, my lord, the affidavit in opposition, my lord.
Let the matter come up on 29th.
Very well, my lord.
What is there, what is with you, and the records as well.
Very well, my lord.
If you require to file any supplementary, we'll see on that.
Very well. Grateful, grateful, my lord.
Grateful, Lordship.
My lord, 102 lordship, I am appearing for the petitioner lordship. I am audible, your lordship.
Yes.
My lord, I have filed this revisional application for quashing of the criminal proceeding, my lord, being the NGR case number 906 of 2013. My lord, which has been initiated pursuant to the suo motu complaint of the police authority. And my lord, the police authority, what they did on the date of occurrence, my lord, the police persons, they entered into the house of the petitioners, my lord, on the ground to catch hold the brother of the petitioner number 1, against whom a warrant was issued pursuant to the complaint of the wife of the brother of the petitioner under section 376 and some and the sections of the NI Act, lordship. Now, lordship, the entire action has been taken by the police authority, my lord, under section 151 of CRPC. Now, my lord, 151 CRPC has clearly stated that arrest to prevent the commission of cognizable offences. Means, my lord, when there is a chance of cognizable offences, the police authority inform the same to his superior. Thereafter, they, my lord, initiate the proceeding against the person he intended to issue the intended to issue the section, lordship. Now, my lord, the sections which has been ultimately given, that is, lordship, section 186 IPC, which is not cognizable offense, section 504 of IPC, which is not cognizable offense, section 506 of IPC, which is not cognizable offense, and section 34 of IPC, my lord, that cannot be stand alone. So, my lord, there is no cognizable offense committed by the petitioners. Even then, the petitioner number 1 was taken to custody under section 151 of CRPC. That too, my lord, without any communication, without any information from the superior. And this, my lord, this criminal proceeding has been started against the petitioners. The petitioner, my lord, the petitioner number 1 has taken to the custody, my lord. He has been beaten mercilessly by the petitioner by the police authority in the custody. Therefore, my lord, the petitioner number 1, my lord, he lodged a complaint against the police authority, my lord, against pursuant to that complaint, my lord, the charges which has been leveled against the police authority are under section 448, 427, 330, 301, 354, 355 of IPC, lordship. Now, my lord, my humble submissions before your lordships, your lordship will get from the depositions of the, not from the deposition, from the statement recorded under 161 CRPC in the case which has been initiated against the police by the petitioner. Your lordship will get from the statement of the medical officer that how the petitioner number was mercilessly beaten by the police authority. My lord, when he was taken to custody under section 151 of CRPC, my lord, assuming that there will be a cognizable offense, but subsequently no cognizable offense has been, my lord, no charges which are the cognizable offense, my lord, have been labeled against the petitioners. So my humble submissions before your lordships, my lord, let both of the CDs of 2 cases, one which has been lodged by the police authority against the petitioner, and one which has been lodged by the petitioner against the police authority, both the CDs may be called for. Lordship will get the all materials how the petitioners have been, my lord, tortured by the police authority in the custody when he was taken under 151 CRPC by the police.
Yes. The service upon the private respondents have been made. There is
My
no
lord,
private.
my lord, there is no private respondent, lordship. The complaint by the police authority is suo moto.
Yes.
So, my lord, there is no private respondent.
SI Kajol Shankar.
Yes, yes. He is the, my lord, the police.
He has been served.
My lord, this is a long pending matter, my lord. I have served, my lord. If your lordship kindly direct me, I will serve again because, my lord, in the meantime, my lord, panel has already been changed. I think, my lord, the learned advocate of the state my lord, has to be, my lord, is to be copies to be served upon him.
Mondol, an advocate for the petitioner, seeks to serve copy of the revisional application upon added opposite party number 2, as well as opposite party number 1 to the Office of Learned Public Prosecutor, and also upon added opposite party number 2 through registered speed post and file affidavit of service on the returnable date. on
Humble
for the petition. Liberty is granted to yes.
My lord, my humble submissions, lordship, can they keep the matter any date, my lord, after 30th of this
After
month? Lord?
complete service, I don't know who is
Yes.
for the state who will appear in this matter.
Yes. But
You are for the
my lord, the next state lordship in that case.
Every Wednesday will be here, your lordship. That is the
So-
given by the public prosecutor.
You will accept that.
Yes, your lordship.
You can give a copy to him.
Yes, kindly record that we have.
You have a
My lord,
copy.
my lord, I will serve him the copy. My lord, may I get his name and number, lordship?
You provide it to her. হবে আসছে না না ওটা সার্ভিস করে আসো অপোজিট পার্টি নাম্বার এ আছে না 2 রিসেন্ট 3 weeks পরে হ্যাঁ 5th August Sir, I have asked on the last week. I have informed Mr. Mondol that to provide one learned advocate on Wednesday from 3:30. These are old criminal matters. Just we get a status report. There are quashing matters. If that has been disposed of, so we can take the status report and dispose of the criminal division.
He has instructed us to be here. We too will be here every Wednesday, your lordship.
Okay, thank you.
Grateful, your lordship.
That one submission, lordship. Kindly, my learned friend will hand over his name and the phone number to my learned junior friend. He's standing over there, lordship. Then I
Provide your name and phone number to him. He will just forward. Yes.
I'm grateful, your lordship. I'm grateful.
Next.
103,
Next.
104,
No. বাইরে আসবেন Sir, what is your name?
Ayok Chakraborty.
Ayok Chakraborty.
অনামিক ব্যানার্জি ফটো দিয়ে দিয়েছি নাম দিয়ে দিয়েছি